fixed to March 20th.
69.
My part
Oblige one.
of back mention, my lord. For listing, my lord. Belgium matter, my lord. And your lordship
Belgium.
fresh matter udaga. Lordship heavy jehetu apana kote heavy burden well on not saying anything. Lordship सब दिन किछि किछि आसीले बेल्जियम गोटा गोटा मिनिट दि चारटा डिस्पोज ऑफ हे जाउछ
We are trying that. Belgium दे दियो.
आगे आगे
I beg.
Belgium लगे दियो.
टॉप
10टा खंडे.
हां प्रतिदिन 10टा आसीले सो दैट गोटे मिनिट दि दिरा डिस्पोज ऑफ हे जाउछ
I
आपनकर
Body so भी केते माने it's not humanly possible to.
हां त हम जानु आपनकर बटनटा जोर तेन करी
I beg.
For consent.
I beg pardon, my lord.
Yes.
My lord, my CRLMC has not been registered due to want of the document, my lord. One document that I have not filed, my lord. Registry is saying that unless until the judicial order is not passed, so they will not accept my document. My cognizance order is there, my lord. Inadvertently, that document has not been delayed.
You file it.
Yeah, unless, my lord, we are supposed to file, my lord.
Why are you bringing your office work to court?
No, well, they are saying that it is a procedure that unless until the
You write
judicial
down subject to office objection, list it before court at my risk. Write it down. That is how things are done.
no, they will not register.
Subject to office objection at my
Okay.
risk, please list before court. You write down in red pen.
Oblige, my lord.
My lord, CRLMC 467 2024 में listed. Actually,
What is that urgency?
urgency is that the persons are the government employees and
Watching.
all
What?
watching. Yes, yes,
Give it.
yes.
Give the memo. Yes.
CLMC fresh matter and questioning the cognizance.
I have pardon to mention, my lord. With permitted to withdraw, my lord. Yesterday, my
Yes, yes. Which item?
20 ଥିଲା, my lord. କାଲି ଥିଲା 20 ସେଟା withdraw ହବ।
Can you withdraw here?
ନା ସେଟା ଆମର ଅଫରଟା ହେଲା withdraw ଥିଲା।
20, you take it. Yesterday, list and
My lord, item 52 permit to withdraw, my lord.
52 withdraw.
My lord, item number 38, my lord, permitted to withdraw.
38 withdraw. Yes. Yes. Item 1.
Item 1.
Your Lordship may
My
be
lord,
pardoned.
I am on VC.
There is a mentioning. Wait.
I am on VC, my lord.
1 minute.
My lord,
1 minute.
CRLM.
1 minute. Are you mentioning?
Yes,
My
Your
lord.
Lordship.
Yes, Mr. Rai, you are mentioning?
My lord.
Yes, yes.
My lord, CRLM May 25 of 2024 may be listed, my lord.
What
The
is that?
modification of the condition imposed by the learned court below, my lords.
Condition on bail.
Yes. This honorable court is directed to release the petitioner on bail on furnishing of bail bond of his family member and another bail bond of the local surety. But that order was differently interpreted by the learned court below, for which he is unable to come outside, my lord.
Let's see. Yes.
CRLM 25 of
Yes. You
2024.
have given a memo, it seems.
My
Is
lord.
there? We'll see. Okay. Yes, Tamanna Patnaik.
Your Lordship, I'm mentioning for CRLMC number 4002 of 2024. Your Lordship, the CRLMC is against the rejection of a discharge petition which has been filed since
Give the
2020.
memo, we'll see.
Yes, Your Lordship.
Item 1.
First one.
Item 2.
May I please, Your Lordship?
Yes.
Here, my lord, the present petitioners, my lord, that 498 case, the present petitioner, two friends, my lord, against them, 294 506. That day I have not made the informant as a party. I have already made the informant as a party. Opposite party not two. If you Lordship see the allegation,
No, where is informant? Have you made the party?
My lord.
But the scan copy doesn't have. Dekho. Yes.
Already consolidated close to.
What is the?
I have filed, my lord.
What are the offences?
294 506. So far, present two petitioners are concerned, my lord. They are friends of the.
Impleted? No. It's not impleted.
Yes, my lord. I have already impleted. That is there,
Item-
my lord. Noting, Your Lordship, kindly have a glance there.
Item 2.
Item 2, my lord. Consolidated cost title filed, kept in record, hence informant is impleted.
It's need a more memo.
Lekha is.
Is there? Okay. Yes. What do you want?
My lord. Your Lordship, kindly have a glance. The FIR, my lord. What allegations against them? 294 506.
Who are you?
Two friends of the husband, my lord.
Your husband and
No, my lord. Two friends of the husband only.
Friends of the husband.
friends of the husband.
What are the allegations against?
The allegation against 29450 your lordship kindly have.
What is the allegation? You tell me. Don't say the section.
That is page 18 FIR my lord. ଆମର ଭୁଆ ଅନୁକୂଳ ସତ୍ତ୍ୱେ 7 ମାର୍ଚ୍ଚ 2022 ଦିନ 2 ସମୟରେ ଅଂଶୁମାନର ପିତା ଦ୍ୱାରିକା ଶତପଥୀ ମା ବିରଳା ଡକ୍ଟର ଅଶୋକ ସାବତ, this one of the petitioner my lord, ସାଙ୍ଗ ବିବେକାନନ୍ଦ ମହାପାତ୍ର ପୂର୍ବ ସୂଚନା ନ ଦେଇ ଆମ ଘରକୁ ଆସି ବିବାହ ବନ୍ଦ କରିବାକୁ କହିଥିଲେ। ଅଂଶୁମାନର ବାପା ମୋ ବାପାକୁ କି ଆପଣ ଜାତିରେ ଚଷା, these allegations are against the father in law my lord. ଅଂଶୁମାନ ତାଙ୍କ ଘରକୁ ନ ନେଇ ଆମ ଘରକୁ ଆସିଲେ, କଳିଙ୍ଗ ଘାଟିକୁ ନେଇ, this is allegation against the ଡକ୍ଟର my lord। ଡକ୍ଟର ଅଛି ସାବତ ଜଣେ ଉଚ୍ଚ ଶିକ୍ଷିତ ହୋଇଥିବା ସତ୍ତ୍ୱେ ମୋତେ ଅଂଶୁମାନ କେପ୍ କରି ରଖିବ ବୋଲି ସମ୍ବୋଧନ କରି ଖରାପ ଭାଷାରେ ଗାଳିଗୁଲଜ କଲେ। ଏମିତି ଗୋଟେ ଇଞ୍ଜେକ୍ସନ ଦେବି କହିକି ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟରେ ହାର୍ଟ ଆଟାକ୍ ଶୋ କରିବ ବୋଲି କହିଲେ। This is the allegation against the petitioners my lord.
Marriage has taken place.
Marriage already court marriage my lord. That they have love affairs during their study my lord. That from the beginning my lord. They have love affairs with this in course of their study. They have court marriage my lord. They have court marriage in the year 2017 my lord.
Why you are standing in their way?
No my lord, I am not. We are not standing my
You are
lord.
going and threatening them.
Only my lord, except this informant my lord, I have annexed my lord the evidence.
Charge sheet filed. Charge sheet filed.
My lord, charge sheet filed my lord. That charge sheet I have annexed the.
You are on bail.
My lord, you are on bail.
I'll issue notice. Let us see. They are happily staying now.
No,
That
my
married.
no, they are living separate.
Against husband and in-laws. They are outsiders.
You have successfully made them separate.
No, my lord. That is the allegation against the all.
That's right. But they were
Parents.
girl and boy have married.
My lord, they have
And
married, my lord.
you are the friend of the father-in-law and mother-in-law of the girl.
No, not
What
a friend of the boy, my lord.
This is at the instance of opposite party number 2 or the FIR number so and so under section so and so registered against the petitioners. Petitioners are the friends of
Husband of the informant.
opposite party number 2. The opposite party number 2. The present case is arising out of a matrimonial discord. However, the present petitioner being not the family member are also roped in. Therefore, the petitioner seeks indulgence of this court for quashing up the FIR qua them. Issue notice to the opposite party, returnable so and so. In the meanwhile, the proceedings before the court so and so stay. Yes.
Item 3.
Settle the dispute. Why unnecessary? Yes.
May I please, Your Lordship? My lord, I have already produced the accused statement, my lord.
Yes.
The fact is that, my lord, impugned order is under Annexure 2, where the 4 petitions were disallowed by London Trial Court, my lord.
What is the 313 to analyze the relevancy of the 5 applications which moved before the London court for leading his defense evidence? What was the application?
Application, sir, one was to call for general diary from the police station, my lord. 2 petitions for calling for general diary.
Achha, where is 313? Have you examined? Mr. Gowda?
Separate copy.
She has moved many applications, about 5 applications.
Now there are 6
Wants to lead defense evidence. And we sought for the 313 statement to see whether these evidences were put to.
separate the copy.
Oh, sir.
You supply the copy, let him examine.
My
Let
lord.
him examine.
My lord.
If the relevant, whatever applications are relevant, we will allow. What is not relevant,
My lord.
let him examine.
Come tomorrow, I have supplied.
Not tomorrow, he let him
My
examine.
lord, 2 तारीख ଅଛି final argument. କାଲି ଆସ।
କେମିତି କରିବେ?
ପହରଦିନ ଆସ।
ଆପଣ ଲଞ୍ଚ ପରେ ଦେଖନ୍ତୁ। Let us pass it over.
ଆଜ୍ଞା।
ଲଞ୍ଚ ପରେ ଯଦି ହଉଛି
ଆଜ୍ଞା।
very difficult to accommodate that.
ଓବଲାଇ।
ଲଞ୍ଚ ପରେ ହେଇଯାଉଛି ବୋଲି କରିଦେବା।
ଆଜ୍ଞା।
ଠିକ ଅଛି। Yes.
Item 4.
May I please, Your Lords? My lord, in this case, there is no case against the petitioner, my lord. Actually, by order of the SP, my lord, the IO has implicated the petitioner, my lord. My lord, may come to page 25 of my petition, my lord. In that, Last 4 lines, my lord.
25. Charge sheet has already been filed.
My lord.
Yes, 25.
My lord, of last four lines, my lord.
One minute,
Of Chittaranjan
One
Pushti,
minute, let me read that. 25, huh?
my
Yes.
lord. Last 4 lines.
Hmm.
Of Chittaranjan Pushti received order from the Superintendent of Police, Bhadrak, by letter number so and so to submit CS against the above noted persons. Hence, I submitted CS under section 467, 468, 471, 420.
No, तारा ऊपर रखो ना. You, what is your name?
Chittaranjan Pushti, man.
Just ऊपर पढ़ना थी. On verification, it came to the light that accused persons are.
This is about all those persons who are.
So arrested accused person, namely so and so. Next, contacted the raid in the house of Chittaranjan Pushti,
My lord.
but found him absent.
My lord.
NBW against him has been obtained. Sir T.R. Das, OPS, so and so, pleased to supervise the case and imparted some valuable instruction for better investigation of the case. Compiled all the instructions imported from so and so note, sent full compliance report so and so, police so and so. Then in your house, the raid was had taken place and incriminating documents were seized. What to do?
My lord, actually,
You are reading last 2 lines for your convenience.
my lord, this is the only line which is implicating me under 109.
But
My
raid has
lord.
taken place in your house and everything is found from your house.
And charge sheet sometimes showing absent.
Charge sheet is found, you are absconding. NBW is issued against you.
My lord.
I'll stay the NBW and go and appear before court and take the remedy, whatever.
Ole.
Okay, I'll stay the. Where is that NBW order? Yes, write down. Although in the FIR number so and so, although in the although in PS FIR PS case number Chandwali
My lord.
Chandwali PS case number 117 of 2015 under section so and so if page 8. The petitioner's name was not mentioned. However, after investigation, the charge sheet is filed against the petitioner. The petitioner have been absconding throughout. Therefore, on 10/3/2023, NBW has been issued against the petitioner by the court of JMFC CBI. Full stop. The petitioner is seeking quashing up for the entire criminal prosecution against him. I'm not inclined to interfere in this matter because material has come on record to implicate the petitioner in this case. However, the NBW issued against the petitioner on 10/3/2023 by JMFC CBI is kept in abeyance till 30th March 2023 for enabling the petitioner to surrender to the jurisdictional court and avail the remedy under law. With this observation, the petition is disposed of. Till 30th March, I have stayed it. You can go and take the remedy. Okay.
Ole.
Yes.
May I please, Your Lord?
Yes.
My lord, the order of cognizance will also get at page 26, annex 3. The cognizance has been taken under section 294, 223, 506, and 34 IPC.
Yes.
All the petitioners are related, they are the father and sons. But the neighbor has lost the FIR. The allegation arising out of from the fact that when the petitioner was installing a AC in the house, the informant opposed the same, saying that the Taja which has been projected by the petitioner, it has encroached to his land, so they are prevented to install the AC. That is the dispute. And they also prevented, and accordingly, there are dispute between two families, and the petitioners first lodged an FIR. The lords will get an annexure
the informant and you are the neighbors.
neighbors, matter, for adjacent neighbors.
How many cases you have?
No, I
Against
have,
each other.
since he prevented me from installing the SC, and
You went and attacked. All the family member went and attacked. That's
no,
the
no,
case.
he lodged an FIR
Hmm.
because he wanted that in presence of the police, at least he can be able to install the SC. After coming to know that the petitioner has lodged the FIR against them, the informant has lodged the present FIR against him, the
What are the offenses?
294, 223, 506.
Yes, Mr. Gowda.
They made a informant of prevent note to my lord this case.
If this is not caused, what will happen? They are neighbors. They'll keep on fighting.
If
It's
notice-
better
My lord,
than
if-
both the FIRs should be caused.
My lord, if the notice reach unfair OP2, then he must be come forward and file another case for passing. Both cases will pass.
Better notice, issue notice. Issue notice to the opposite party. Where is the opposite party? Yes, opposite party, number 2. Opposite party number 2. Then council for the petitioner submits that the opposite party number 2 is their neighbor. Is there? Is the neighbor of the petitioners, neighbor of the petitioner. Due to what was the allegation? Let us see.
When he was in annexure 1 is the
Now, you
FIR.
tell me, I'll write it down.
When he was installing SC in his
When the
house,
opposite party number 2 was installing AC.
now the petitioner was
When the
installing it.
petitioners were installing the AC,
The opposite party number 2 opposed the same
opposite party number 2 opposed the same
and subsequently lost the FIR.
No, abuse him in the optional language.
opposed the same
Attack him by iron rod.
and
Abuse him and attack him by
LS to have assaulted the opposite party number 2.
Not
Therefore-
assaulted, tried to.
Therefore, the FIR. Issue
Yes.
notice to the opposite party number 2. In the meanwhile, the proceeding is started. Proceeding before the court. Where is that? Proceeding before
Call was taken already.
the court of JMFC Rural Cuttack in GR case number 1113 of 2021 in state till the next data period. You bring him. Let us see. We can find out.
Yes.
Yes,
Item 6.
Stay up for the proceeding. I have.
I have done it. If you don't want, then I'll remove that.
I'm not obliged.
Yes.
Item 6.
Item 6, my lord. The last opinion, it has been adjourned as because I am not serving copy to the vigilance department.
Yes, urgent. Save the copy.
Yes.
Yes.
Here in this case, my lord, the petitioner challenging.
No,
order
no.
dated
You want
8
an adjournment?
No, my lord. Already copy has
Oh.
been served. That is my assumption.
Item 6, yes, item 6, yes, tell me.
In this case, my lord, the order of cognizance dated 8/12/2015 has been challenged, my lord.
Hmm.
My lord, the cognizance has been taken. Then offense under section 13(2), read with section 13(1)(c) of the PC Act, my lord.
Hmm.
The calculation which has been done, my lord, the vigilance authority into the tune of rupees 54,96,600 again income of rupees
You have come
56,000.
against the cognizance order
Yes, my lord.
in a PC case.
Yes, my lord. But my humble submission, my lord, kindly appreciate, my lord. The differential amount not making any vast gap, my lord. And the
But,
parental property
PC case, you know, it is just.
and the long-term deposit,
And the revision is also not entertainable.
the long-term deposit are also not taken into consideration, my lord. And it is a case of year 2013, my lord. The petition is a 66-year-old and out of 41 charge sheeted,
FIR is 2013. Huh?
my lord, case initiated in the year 2015. Out
What
of-
is the stage of the trial?
Vigilance.
Huh?
Only-
Vigilance case.
Vigilance case.
My lord, only out of only
Let him come, pass. Vigilance case. Yes, next. Pass over.
after launch, my lord.
Pass over is after lunch only. Yes.
Item 7.
My lordship, your my lord. This petition
Yes.
is challenged order of taking cognizance, my lord. So that is on a protest petition lordship. So this summons has been issued to him, my lord, under section 447, 427.
Yes, yes. Tell me what are the allegations?
So allegation lordships because and he had filed an FIR against this petition, my lord, in 2019, my lord. and the FIR lost in 2020, Lordship. Thereafter, the matter was investigated into by the IO. And the IO submitted the final report because so that this allegation against this petition is false.
And
So-
the protest petition is filed and protest petition evidences are recorded and cognizance is
Lost.
taken.
So once the two witnesses have been examined, one is this complainant, the OP number 2 here in Lordship, and his nephew, Lordship. So they have not stated what they have stated in the FIR, Lordship. So there are contradictions, and another Lordship will find. So what has happened? So background.
At this stage of cognizance, do I need to go into the fact that who has contradicted what?
So the statement
The
was recorded
statement,
by
the
the court
statement
during
at
do not
200
mind.
recorded
Yes, Lord.
makes out a case, wrong, right,
So-
whatever.
so that
Cognizance
is-
is taken. What to
because-
do?
Because same self allegation and he has made the allegation.
Whatever may be, the allegations are maybe motivated
So, Lordship,
allegation, wrong
background-
allegation, whatever. At the cognizance stage, how can I go into all
So,
this?
Lordship, that has not been considered. The details of the fact has not been considered, Lordship. Just background, Lordship. What has happened here, Lordship? This complainant has a land, Lordship. It is arising out of a civil dispute, Lordship. Has a land in 2001, my lord. And he had mortgaged before the OSFC, Lordship. And also when he failed to repay the loan, so that was auctioned. In auction, one man, some Senapati, was auction holder, and he purchased the property from the.
All these facts has to be brought on record.
So is there in the record,
How-
Lordship?
how-
This police, the IO has submitted the charge sheet, Lordship. Lordship, see.
I know,
Page 22.
I've just seen it.
Yes, page 22, Lordship. That's page 31, Lordship. So there, everything has been written, Lordship. And because this allegation.
Where are the statement under 200?
Statement, because I have not filed, so I have got their, Lordship.
You file that, then only we'll see whether those statement, whether any case is made out or not.
So,
Because cognizance is taken on the protest petition. Though
Yes,
on
yes,
the basis of the statement.
So, Lordship.
I
only
just show me the
because-
statement.
Because once
Read
the
the
20
statement.
So I plead, Lordship, because the 25, the cognizance has been taken against this petition under section 25 of the Arms Act, my lord. And pointing a gun on his head and threatened that to do not come on the land, my lord. So in that matter, Lordship, so independent witnesses have not been examined.
Not necessary, you will get acquitted at the cognizance stage. I need
so
not
Lordship-
go into all this.
So Lordship, I place on surrender, I be released on bail. That.
Come to that point. That is the object, not
So, Lordship.
for, you know that you don't have a case.
So, Lordship,
But
Lordship.
the problem is you are not on bail.
That.
I'll protect you till
That-
30th March, you go and do.
So Lordship. Lordship,
See, ideally, I should not do it. It is, but this matter is pending for a longer time. I'll just protect you till then. NBW is issued against you.
No, my lord. So appearance because someone was issued
Unless,
because
the,
25 arms are there.
Petitioner has filed the present petition assailing the order dated 12/4/2023 passed by
With the Lawrence Session Judge Bhubaneswar for law.
Learned Sessions Judge Bhubaneswar in
My lord, once is case
in
number 1 of
1CC
2022.
bracket protest petition case number 1 dash 2022.
1CC number 1 of 22, my lord.
1/2022. 1/2020. Right. The petitioner seeks to withdraw the present petition to approach the court at appropriate stage, and on instruction submits that his client would be appearing before the court below on or before 30th of March so and so to and seek remedy available to him under law. He may do so on or before he may do so. The petitioner may do so on or before 30th March so and so. Till then, no prosecution.
Item 8. There are 3 petitioners. And they have been. There are 3 petitioners and there is a vigilance case.
8, item 8.
8,
Yes.
The vigilance case was instituted as back as in 2010 And trial court registered the case in 2011. And out of 10 charge sheeted witnesses, my lord, 8 witnesses have been examined before COVID. And after COVID, my lord, no witnesses could be examined, and there are only 2 witnesses left. I pray your lordship to target the case that what has happened, my lord, out of these 3 petitioners, 2 are suffering from cancer. They have been superannuated. And another man is
When was the case registered?
Case, my lord, it was registered as per the FIR on 30th March 2010.
Vigilance case. Vigilance dena nahi.
Vigilance case, I am passing it over. Let him come.
My lord, wrongly I have solved the
Sir,
copy.
vigilance, one of the.
It may be handed over
Vigilance
to.
is there, man, he filed the.
Give a copy to him.
State's copy, my lord.
Where is your advocate?
My lord, I may be permitted.
Huh? What to do?
I am serving another copy, my lord, another date, my lord.
Because give it short date with you.
Next week, my lord.
Petitioners are suffering from cancer.
Well, 2 of the petitioners are cancer patients, and one of the petitioner, my lord, due to his old age, he is suffering from heart ailments. Heart
So
disease.
give little. 12.
Password.
Yes, pass over.
Compromise affidavit. After lunch.
No problem.
My lord, item 10, I am challenging the interim maintenance, my lord. I am the husband, my lord. My lord, the interim order is 32, my lord, 3,000 per month. But my lord, I am submitting, my lord.
Maintenance, how are you coming to this court?
So it is against the 125 CRPC, my lord.
125.
My lord.
There is no other remedy.
No, my lord.
No, I think-
Shall maintain.
Anyway, what are you doing?
I am, my lord, I am jobless, my lord. And my wife, I am jobless, my lord. And my wife is it.
Because you married, therefore jobless.
Yes.
Why have you married then, if you are jobless?
Unfortunately, my parents had married me, my lord.
While
My lord,
marriage, you might have said that I am doing this, that.
My lord,
And after marriage, some dispute came, then you become unemployed.
Before that, I have
What is
resigned.
your wife doing?
My wife is a tailoring, has a tailoring shop, and she is also selling more, my lord.
Go and join and help.
And my lord, what I am submitting, my lord, your lordship may issue notice because after
Simply issue notice and there can't be.
and so that your lordship is sent for the mediation, so it may settle, my lord.
We simply issue notice, let us.
And thala kote proceeding ta hejo, my lord. Lordship, till next date, my lord.
No question.
Execution proceeding
In a
hejo.
maintenance case, we don't know whether you are working or not. You should work. What is your qualification?
My qualification is +3.
Then you are sufficiently educated. You are supposed to take care of your
And
wife.
my
You
wife,
married, then you have to take care.
my wife, my lord, is a tuition is.
If you don't pay anything, she has to do something or the other. What to do?
Earlier she was doing, my lord. And my lord, what I am submitting, my
I'm
lord.
simply issuing notice.
My lord,
Otherwise, I'll dismiss it. What do you
no,
want?
no, well, I pardon, my lord. My marriage was 6 July 21, and she left the company 25/11/21.
This
And
is
what I'm suggesting, what am I?
This is your side of story. When she
No,
will
no,
come, the story will something else.
No, it is on record, my lord. I have relied on it. Your lordship.
I have issued notice. Be satisfied on that. Give a short date so that we can see. You can sort it out. Keep short date. Okay.
My lord, may I pray, my lord? Till next date. Your lordship.
Maintenance case, why are you?
No, so that what is that day, my lord?
Heaven is not going to fall. How much? 10,000 rupees. If you don't pay by the next time she will come, we will settle it.
My lord.
Only 10,000 rupees. And today's this thing, minimum 10,000 rupees somebody wants, to survive. How many? You have any children?
No, my lord. Only 4 months, my lord.
Anyway.
Yes, ma'am.
Give 10,000.
Yes.
Next.
Item 11.
Antaryami. May I please, my lord?
Yes.
And this is an application challenging the order passed by the Lorraine Court below, rejecting my application on section 457 in the release of a vehicle, my lord. My lord, on the ground that the registered owner of the vehicle is somebody else, Ladukishore Sahu, from whom I have purchased. And there is also a sale agreement. In that sale agreement, the cost of the price was 4 lakhs. Out of 4 lakhs, I had paid only 2 lakhs 50. That is the consideration as to why, since I have not paid.
50% owner.
My lord,
Then you are entitled for 50%.
No, my lord, I have already paid. I have also filed an affidavit of the the owner of the
It is
vehicle.
rejected on what ground? That
On
you are
the-
not the owner.
On the ground that I am not the registered, not that I have not paid the clear the total amount. That is there.
Why don't you clear the total amount?
I have already cleared. I have also filed an affidavit to that effect, my lord. The owner has also.
Then now you go to the court. Where is that order, impugn order?
My lord, that is at page.
Which annexure?
After petition.
My lord, that is annexure, my lord, 1, my lord.
This is 5/1/2024, the impugn order.
My
The
lord.
agreement is,
My lord.
when have you paid the money?
My lord, I have already paid the amount on the affidavit, my lord, at page 23, my lord.
No,
Sorry,
no.
sorry.
The affidavit is 24th
My lord.
January 2024.
My lord, my lord.
And the
after the order was passed.
impugn order is passed, no, 5 January, 5th January. 5th January.
5th January.
Look, the petitioner's application under 457 CRPC for releasing of Chevrolet SIL 1.3. What is the vehicle?
That is a car, my lord.
Which car is this?
My lord, Chevrolet car.
Chevrolet.
My lord.
Bearing number OD. OD-18 AO 7699.
My lord.
Yes.
Has been rejected by the court below by the order dated 5/1/2024. Inter alia stating that he could not establish that he is the owner of the vehicle. The counsel for the petitioner submits that in fact the original owner, what is his original owner name?
My lord.
Original owner name.
Ladukishore Sahu, the original
The owner of the vehicle is Ladukishore Sahu, from whom he has purchased the vehicle. He has placed on record various documents to suggest that the sale consideration of the vehicle has already been paid to the original registered owner, and is relying upon where is that?
My lord, at page.
Relying upon an affidavit. Dated 25th January 2024, filed by the.
My lord, that is 29th January.
It is 25th, it is written. What to do?
My lord, that affidavit is annexed.
But they solemnly affirm and sign on 25th day of January 2024.
My lord.
Which date I'll say?
But it has been signed by the executive magistrate on 29th.
Whatever. And affidavit stated. Shown in by the registered owner, which is attested on 29/1/2024.
Right.
24. Relying upon the said document, the petitioners petitioner submits that he is the owner of the vehicle. Since these documents were not available before the court below, there is no fault, not below the impugn order was justified. Having said that, the petitioner is now given liberty to approach the court below with all these documents and revive his application under 457 CRPC. In view of the aforesaid, the impugn order dated 5/1/2024 is set aside.
and liberty is granted.
My lord.
Yes. Item 12.
My lord, that next item is, my lord, that is in respect of a mobile phone, my lord, have a glance to the voucher, my lord. My lord, in the voucher, the salesman has wrongly noted my name as one author Jamu Guntha.
What can I do?
But my name is Antarjami, but he is illiterate, my lord. Salesman, my lord, may have a glance to the voucher, my lord. See Antarjami again, lekhi parlani. Chitaku lekhida Antarjami. The Lord Court below has rejected my application.
In respect of that, my lord, the
Antarjami.
Antarjami. But he has stated Antarjami.
That is why you are
See,
applying.
my lord, my lord.
Your application, where is that application?
excluding that, my lord, I may be pardoned. Excluding that, my lord, the seized mobile belongs to the other company. But the
Other?
voucher has been served in a different company. That is Redmi telephone.
Where is that order?
My lord,
Order is?
my lord, that is at annexed.
Where is
My
the-
lord, at page 17, my lord.
Page number is
17.
My lord. Annexure 4.
Annexure 4 is not there with me.
File it, my lord.
Where is that?
They are the MC number 208 of 2023.
Annexure 4.
My lord.
Sale agreement.
No, my lord. This
Which
is
item here?
my lord, item number, that is wrongly, that is item 11.
11.
It is ulta palta hi jaychi.
You have submitted first item number 12.
My lord. Se same jinso, gotti lokoro ta aigna dita eport
Sale
supply
agreement,
jaychi.
some sale agreement.
My lord.
Huh?
Eita. Annexure 4
Annexure 4 is sale agreement.
No, seita olgata. Again.
Huh?
My lord, okay.
Put the record straight. How can I? Annexure, you are saying annexure 4 as page 23, it is a sale agreement.
That has been wrongly,
And,
wrongly tagged, perhaps.
Everything is here.
Wrongly tagged.
You said it right.
My lord.
You said the record.
Just now I am sitting.
Then pass it over, let us. 11, okay.
Item 13.
May I please, Lords?
But item 12 only you have to check. Annexures may be here and there.
May I please, Lords?
Yes.
The petition is challenging to quash the NBW order dated 14/11/2023, my lord.
Yes. When you got the bail?
I got the bail, my lord,
11.
under Annexure 1, my lord, 11/2/2020, my lord.
11 to
2020,
20.
my lord.
500.
Okay.
Honor for 20 seconds.
Obliged.
Item 14.
20. Additional 20. Yes.
14.
14.
Wait, please, Lordship.
Yes.
My lords, this is a case, my lords, where I have challenged Annexure 9, my lords, at 187. Annexure 9 starts at 187, my lords. The petitioner is the inspector in charge, Sadar Police, my lords. Lordship would kindly come to Annexure 9, page 187.
9, huh?
My lords, Lordship would
Yes.
kindly come to page 191, the relevant portion, my lords.
191.
My lord.
Okay.
My lord, this is an order dated 4/10/2019. My lord has. My lord, on this date, my lords, cognizance was taken against 9 separate people. I was not named in the charge sheet, my lords.
No. Receive the order. Why do we want it?
My lords, 4/10/2019, CS charge sheet number 17 dated 27/9/2019 has been received from the IO.
17. Charge sheet number 17, huh?
My lords, has been received from the IO against the accused persons, namely so and so, till Kailash Chandra Parija, serial number 9.
You have.
I am not named here, my lords.
Kailash Chandra Parija.
I am not named. The petitioner is, my lords, Bikram Keshari Jena. I am not named here, my lords.
No, in the charge sheet you are not.
Not named. Then what happens, my lords? Then another order comes in, 20th of February 2020, just below it, my lords.
No, let us
Sorry.
confirm this.
Yes.
4/10/2019, cognizance has been taken against many people.
Yes, my lord.
Including one Kailash Chandra Parija.
Yes, 9 people.
The
my lord.
Kailash Chandra Parija was not in the charge sheet at
My
all.
lords, the petitioner Bikram Keshari Jena. I am the petitioner, my lords. petitioner is Bikram Keshari
He's
Jana.
not there, he's not
Yes,
there.
yes, my lords.
Okay,
Yes,
okay.
my lords. The my lords will kindly come to order dated 20th of February 2020. Just below that, my lords.
February 2020. Okay. February, 20th February.
Same page, my lord, 191 at the bottom, my lords.
Hey, 1 minute. 121. Yes, yes.
My lord has it.
Hmm.
20
Hmm.
A supplementary charge sheet is filed by a subsequent IO, my lords. First IO, my lord, 161 happens, 164 happens, all recordings are done.
What is wrong in supplementary charge sheet? You
Yes,
have
ma'am.
made it there.
Yes, ma'am. It comes. Second, supplementary charge sheet hasn't filed. Here again, 11 people have been named, my lords. I am not named, my lords.
In supplementary also.
Yes, I am not named.
Very good.
My lord will kindly come to page 194.
Yes.
Page 194, my lords, order dated 21/6/2021. That is 3 years after, my lords. My lords, here I am named as accused number 13.
Further supplementary, further charge.
Further supplementary charge sheet. Here I am named up. From here onwards, I'll take your lordship straight away to page 179. That is the relevant portion of the charge sheet where I am referred to.
170.
My lord.
Charge sheet, huh?
Again, 179 is a relevant portion again. It starts from page 44 onwards, but relevant portion is 179. 47 आरंभ होचे, but relevant portion टा page 179 नोच.
78, yeah, 17. Okay.
I have shown the first was by the first IO, second supplementary was by a subsequent IO. Again, the supplementary was by the same IO, second supplementary IO. In the first supplementary charge sheet, she does not name me. However, the second supplementary charge sheet, she names me, lords. I would kindly come to 179. Para 116.16, my lord.
16.
Yes, madam.
Okay.
16.16.
During the course of
investigation, truck owners, namely Ranjan Kumar Mahapatra, Narayan Sahu, Asim Rautar, Lingaraj Parida, Manoranjan Parida, Basant Sahu, who were illegally carrying stones from the quarries, were examined and the statements were recorded under 161 CRPC, my lord. These are the people whom I had prosecuted, my lords, for illegal crimes, and I had penalized them. They were arrested. They are co-accused in this case.
Who are you, by the way?
Well, I was ISC Sadar during that time when the investigation was going on regarding illegal quarrying and illegal transportation, my lords.
You are the IIT up to that.
During that time, my lords. And even I was recommended for Home Minister medal. I got it. Even during President medal, I was recommended. Just 2 days after my case has been registered against me.
Yes.
I'll come to that, my lords.
They have confessed.
They have confessed that illegally, deliberately transported stones from the quarries with clandestine help from Bikram Keshari Jana, my lords, and Ranjit Kumar Sahu, Inspectors Police Sadar PS,
Bikram case.
and Bikram Keshari Jana, my lords. The co-accused has named me, my lords.
Inspector of the police, Sadar PS, respectively.
Sorry, my lords.
Take how many? Read it.
Sir.
Money and then.
The statement has been recorded under 161 CRPC, which is reiterated the same. The statement under 164 CRPC also itself is inculpatory as well as reveals the entanglement of Bikram Jana and Ranjit Kumar Sahu since the evidence of
The problem seems to be 164.
Yes, my lords. Let's kindly come to the next page, my lords. Sorry, my lords.
How will you get out of one?
But may I come? I'll just show 3-4 pages, then I'll leave it to lordship, my lords. Kind consideration. Page 180, my lords. Lordship has seen that.
180.
180, very next page, my lords. It says that they are the real plunderers of the property. Then, my lords, it says there is evidence of involvement of Mr. Bikram Keshari Jana and Ranjit Kumar Sahu in forms of statements of 6 truck owners. It is their statement, the co-accused statements only, and CDR and CD analysis and other statements which establish that they got money from truck owner transportation.
164 statement which is recorded, they
My
are
lord.
they also accused.
Yes, they are the accused, my lords. These co-accused, my lords. Sir, from the statements of 6 truck owners. May I read it once? I'm sorry.
Yes, Mr. Raul. Are they co-accused?
I will take instruction, my lord, because this is a.
They are co-accused.
No, if they are co-accused,
yes, my lord.
On the basis of their statement, you are bringing an IO who has prosecuted the same co-accused in another case.
The entire documents will be filed by the friend. That is there, but so far the entire city is required. So the also I take instruction in this regard. I will get the city.
Page 40 to page 43 will show that I was recommended, and I got it from. I was the first person in Orissa to get medal from the Home Minister. Then I was recommended for president.
In the third supplementary charge sheet, his name comes.
Yes, yes.
On the basis of the 161 statement and 164 statement of the co-accused persons.
Yes.
And those
The
statements
same
are there.
co-accused persons were prosecuted by him.
Yes, madam.
Yes, ma'am.
For some other cases. How can you bring the IIC?
Yes, my lord, that is the fact, my lord, but I have to take instruction.
Yes.
Then I'll have to stay qua him.
Yes. Sir.
Yes.
So that in respect of this petition.
Yes, ma'am. Yes, ma'am.
I'll have to stay.
In
Yeah, I know.
respect of this.
The petitioner is in the present petition, petitioner has challenged the cognizance order dated.
Order
the
dated
order dated 7. What is that?
My lord, it's
27/5/2021. Whereby
21/6/21. 21/6/21. Issuing process, my lord. First day, it was one. I was issued process after the.
Okay, 21/6/2021, whereby the process has been issued by the SDGM Kurda in GR case number 486 of 2019, arising out of STF case number 7 of 2019 against the petitioner. Then consequently, the petitioner submits that his name was neither in the FIR nor in the first 2 charge sheets filed by the police. Eventually, in the on the 3rd supplementary charge sheet, petitioner is an IAC of
Presently working here. At that time, he was IAC Sadar PS. My lord, presently
petitioner is a police officer and was IAC of which
for the PS.
For
the PS.
During his tenure as an IAC, he had prosecuted a couple of people for illegal mining. He has also prosecuted the co-accused in the present case. Full stop. The same co-accused persons have deposed against the petitioner in the instant case under 161 statement. Under 161 CRPC statement. The witnesses were also subjected to the statement of the said co-accused persons were also recorded under 164. The very fact that 164, what was the occasion for recording 164? That itself shows.
Yes.
The said co-accused persons, the statement of the said co-accused persons were also recorded under 164. 164 CRPC. Also, on the basis of these materials, the petitioner has been charge sheeted in the second supplementary charge. And the learned court below has taken cognizance while order dated 27/5/2021, and subsequently process has been issued by imbue. If you notice the opposite party returnable on so and so, in the meantime, proceeding qua the petitioner in GR in which case number in
GR case number
486 of 2019, arising out of STF case number 486 of 2019, pending before the.
Well, it will be 7. 486. It will be 7. 7. I got over 7. Like 486.
80.
STF case number 7 of 2019.
See your application.
In the IA, it is mistake. In the main petition is correct. It is our mistake.
At the problem.
It is our mistake. We apologize for that.
Rely upon what? I don't know.
7.
STF case number
7 of 2019. My mistake. So I completely apologize for that.
7 of 2019. 7 of 29. Pending in the court of
SDGM.
Which court? SDGM.
Again, SDGM court. Khurda again.
SDGM Khurda. State in the yes.
Sorry, once again.
But correct it.
I will correct right away. Will correct.
Yes, now correct. In both the applications, they know. Yes.
12.
12 recording.
It is correct there. My lord, impugned order at page 17, my lord, may have a glance. Last 4 to 5 lines. Page 17, my lord.
Name of the
name of the accused has not been mentioned on the invoice of the phone bill. Further, the cash bill mobile does not contain the
Any GST PIN number? No.
That is the doubtful, is what to do.
My lord, only name.
Name and GST number also.
My lord, usually nowadays they are not using such.
Nowadays only they do GST.
That is why
Earlier it was no GST.
I will suffer, my lord.
Where is that?
My lord, invoice at page 15, my lord. Invoice at page 15. Instead of Antarjami, he has mentioned as Authoriam. It is the salesman who has written so.
29,000. It's a costly mobile. It was seized when?
My lord, it has been seized since at page 14, my lord.
Item number
Since-
12.
My
My lord, enter two file, my lord. 12 and 10, my lord. Oh, there is no paging mark. There is no
I know,
systematically rejection order is not
Eight,
filed,
six.
my lord. Totally clumsy, my lord, to understand, and I am also unable to give the understand to my lord.
8/6,
He is
2000.
entitled for, because this mess you created, he is entitled for a day. And without mobile, you must be having an alternate mobile. You are managing. Now you manage for some time.
So one of Android,
I will supply a copy.
no, one of Android mobile has been seized,
I-
my lord.
I will supply a copy.
Yes. Next, 14. 15.
15, your lordship has already decided this issue so far as the cognizance is taken. And your lordship has quashed so far as the payment of TDS with interest within the COVID period. Same periods, your lordship say 83 days, all the same, your lordship already quashed. So your lordship, only COVID period, that is nothing. And 270 says,
You paid the interest.
yes, yes, that has been, that your lordship see the order itself.
What
That-
is it?
Lordship see for 61.
1 minute. If there is no opposition, why?
Oh, no, I don't, sorry.
You provoking him to oppose you.
No, definitely, he has every right.
So fairly saying.
No,
He
definitely.
also knows that.
Yes, I have already served the copy prior to.
But some cost you have to pay.
Sorry?
Some cost you have to pay to the bar.
As your lordship, yes, I don't have any objection to that.
That is the only solar time. Right now. Petitioner is questioning the criminal prosecution launched against him. Nay, what is the party kindly satisfied? It was order dated? What?
Order dated,
Cognizance order.
Cognizance, yes, lordship.
Okay. Petitioner has essayed order dated 22/2/2023.
Yes.
Passed by
By ACGM special cut.
ACJM
special cut. Special cut.
Special Cuttack, Special Court,
Yes.
bracket Cuttack, in
2cc 10 by 8, 10 by 23.
Whereby the court below has taken cognizance of offence under section
276B.
276B. It doesn't go. 276B. Solo, page 4. 276B, comma 2 bracket 35 and
278B
of ITA.
Yes.
No. Accordingly, the cognizance is taken 276B. Yes. ITA of 1961. 1960. The allegation against the petitioner is what is the allegation?
Allegation is not paid the TDS dues within the stipulated period.
Although he has collected TDS from the source of his clients, but he has not deposited the TDS amount within time. The letter counsel petitioner submits that there was a delay in depositing the TDS amount. He has how many days delay?
83 days maximum.
There was 83 days delay in depositing the TDS amount. He has deposited the TDS amount along with the interest
Prior to initiation of the proceeding.
Interest prior to the
Initiation of the
proceeding by the department. And the delay he is submitting the counsel petitioner further submits that the delay has been caused due to the
COVID-19.
prevailing COVID in the intervening
prevailing COVID. Therefore, the delay in the range of one. Mr. Mohanty, standing counsel appearing for the opposite party on a submission, vehemently oppose the prayer made by the petitioner, and he submits that the non-compliance of the provisions of the Act attracts the offence under section 276B of the income tax. Therefore, the court has rightly taken cognizance. However, he fairly submits that since delay is caused due to the COVID-19 pandemic, lenient view could be taken in the present case. Having regard to the fact and submission of the bar, in the light of the fact that the petitioner has already deposited the TDS amount along with the interest before the prosecution was launched against him, I am of the considered view that the prosecution lodged against the petitioner deserves to be quashed. Accordingly, the cognizance order dated 22/2/2023 passed by ACJM Special Cuttack in
2CC case number.
2CC case number
10 by 20.
of 2023 was subject to the petitioner paying how much?
Actually,
You are a businessman, you can pay 5,000?
no, not 2,000. 2,000.
2,000.
Yes.
To the bar. Welfare fund.
Yes. I mean, along with my name, let's see Parida may be mentioned.
See Parida, you must.
Much obliged.
Item 16.
कितना अच्छी है
16.
नहीं, how many foreign people are there? Belgium pura
Belgium.
Yes. 16 कौन तू?
Nobody is there.
Yes.
17.
May I please, your lordship?
Yes, yes. Tell me.
Lordship,
When you got bail?
Bail got 19 to 2019.
19 to 2000 and NBW is
1/1/2023.
age also 2003. ठीक है 500. Yes.
Obliged, ma'am.
I beg pardon for this moment, Lords. Item 16.
16. Yes, tell me.
Your Lordship said it's a Belgium matter. Your Lordship's
Bail.
petition-
When you got bail?
Your Lordships have got bail, Lordships, on 29/10/2021, petition of 1, and 2 is on 2/9/2022, Lordships.
22. 500 each. 500 each. No.
Item 18.
May I please? Belgium matter, my lord, NBW 61016 and bail, my lord, 830 2007, my lord. Bail.
Bail, you tell me date.
8 March. 8th of March.
8 March
2007.
2007. NBW
61016.
16. How many of you are there?
One man.
1000.
Obliged.
Yes. 20th.
Item 19.
19.
Belgium matter, my lord.
Yes.
The petitioner was on bail on 2/8/2023. NBW was issued on 23rd/11/2023, my lord.
500. 500. Yes.
Item 20.
20, my lord, I was on bail on 25th February 2020 and NBW was issued on 22nd to September 2022, my lord.
500.
Item 21.
21, my lord. Bail, my lord, 3/8/17. The anticipated bail. And NBW, my lord, 18.
Will you do it after lunch, after having lunch?
No.
Why don't you speak loudly? You're a young man. Or I'll take it up at after lunch. You
No, my
have
lord.
lunch and come.
No, I will.
Gather some energy.
No.
Yes.
Bail, my lord, 3/8/17, my lord.
Yes.
Anticipated bail.
Hmm.
And NBW, my lord, 18/6/19.
Okay. 19.
19, my.
Oh, you have to give 1000. And
Two-
500 each.
Yes, ma'am.
500
Obliged.
each. Okay.
Obliged.
Yes.
22.
May I please, lordship? The petitioner agreed by NBW issued on 5/7/23 and passed by SDGM Panforce in execution case arising out of
Tell me when you got the bail.
no, lordship. In
Separate proceeding.
It is the
It's a
case.
DB maintenance proceeding.
Huh?
Maintenance proceeding,
No.
he has not paid the amount, area amount, 4,70,000.
Area amount you have to pay.
Let's say now is Annex 3 my counseling is going on, and the opposite party, the wife, has filed a counts money say under section 9 for restitution conjugal rights.
For non-payment of the maintenance amount, a execution petition was initiated by the opposite party number 2, being opposite party number 2, where is that? Where is that?
Anjulata Sahu.
Being execution miss case number 376 of 2022. Arising out of DV miss case number 213 of 2018. So, sir, NBW has been issued by the court below against the petitioner on 5/7/2023. Then counsel the petitioner submits that the conciliation proceeding between the parties, between petitioner and opposite party number 2 is going on.
In the family court.
Going on before the family court.
Family court, Sambalpur.
When the matter is fixed?
Date count is I have not date is fixed.
Taking into consideration the fact that the parties are exploring the possibility of settlement before the family court Sambalpur, the NBW issued by the court below dated 5/7/2023 is kept in abeyance till 15th April 2020. Last item.
Notice was issued, my lord.
No, dispose of cancellation is going on. I kept it in events.
For a certain period. For a certain period
only. Yeah. Because otherwise she will come, waste money, engage lawyer. Why unnecessary?
Yes.
Conciliation is going on. Let it. Yes, 23rd.
NBW was issued on 13/6/2023, my lord.
No, bail. When you got bail? When you got bail?
So bail was anticipatory, that was in 2017, my lord. Annexed lots.
Date.
Date is lots, that is 1/9/2017, my lord.
1/9/73 LDC bail. NBW
13/6/2023.
How many of you are there?
3 lots.
3.
Yes,
I will ready.
My lord.
You'll also may kindly mention the ABLPL number, so that is.
ABLPL number.
I have annexed on. That's
one minute.
I have annexed ABLPL.
The petitioner was on bail. Petitioner was on bail on such day. Granted by
this on the
coordinated bench of this court.
Yeah.
In ABPL number 13349 of 2017.
Right.
Sir is sitting.
24.
Can I just?
Yes.
perspective of the matter.
Yes.
My lords, here the allegation against my client is, my lords, that he was an agent of a cryptocurrency styled as Yes Money.
Yes, what?
Now, Yes World. Now, this Yes World is an international cryptocurrency which is there in the portals itself. It is there in the wallet, my lords, and he was functioning as an agent. There is nothing illegal in a cryptocurrency, my lords, and it has been approved by the Supreme Court. I will show your lordships. And Government of India is charging 32
plus 4.
28 plus 4% cess on cryptocurrency, my lords. There was a RBI circular asking asking banks not to open up accounts of people who deal with cryptocurrency. Now, this was challenged before the Apex Court, and the Apex Court said, no, the cryptocurrency is not illegal, and it is not banned in India, not banned anywhere in the world, and there are no regulatory measures to regulate the sale or otherwise or distribution of cryptocurrency.
RBI and SEBI has failed.
And RBI and SEBI, they have never issued any regulatory guidelines. Now, my lords, I am admittedly an agent of Yes World. Now, if I am an agent of Yes World and I am doing something legal, for example, my lords, Dalals on Dalal Street, my lords, they deal with shares. Now, Adani shares they were dealing with, suddenly this Hindenburg report comes in, Adani shares crashed. Does it mean that the Dalal is a cheat? It is your option. I have, my lords, like they sell insurance, mutual funds, invest in this, invest in that. And people,
what kind of instruction you want him to get?
My lords, let him find out how the entire allegation is the cryptocurrency is fake. Now, this cryptocurrency is a fake currency, my lords. That, your lordship, the Supreme Court and Internet and Mobile Association of India.
Yeah, the recent judgment.
Yes, my lords. They have categorically held that this is a judgment by Justice Nariman, my lords. They have categorically held, if your lordship sees,
Page 176.
176.
173. Yes.
6.171.
Yes.
In case the said enactment, the lordship gets it. 176 is 6.171.
Yes.
In case the said enactment 2019 had come through, there would have been an official digital currency for the creation and circulation of which RBI central government would have had a monopoly. But that situation had not arisen. The position as on date is that VCs are not banned with virtual currency. My lords, this money is also, but the trading in VCs and the functioning of VC exchanges are sent to comatose by the impugned circular by disconnecting the lifeline, namely the interface with the regular banking sector. This was what was challenged before the Supreme Court.
Yes.
What is worse is that this has been done, one, despite RBI not finding anything wrong about the way in which these exchanges function, and two, despite the fact that VCs are not banned. This is a categorical finding of the Supreme Court, and this investigating officer, he doesn't understand what cryptocurrency is all about. It's just like shares, my lords. I induce people to invest in this, and my lords, he's got hold of this man and kept him behind bars, and he's saying that it's a Ponzi scheme. Well, how does it become a Ponzi scheme? And I have nothing has flowed to my account. Not a single paisa has flowed to my account.
They invest from their own
They
account.
invest from their own accounts. The option is on the investors.
How many of you are there?
My lords, somewhere around, they say there is one person who has lost an FIR. They say there are 8,000 or some odd. My lords, if the cryptocurrency falls, that is not the fault of the dealer.
What is the
criminal
extent of the loss alleged?
There's no loss.
There's no loss, my lords. The loss is with the my lords, the particular person who has come forward says he has invested.
I'll just issue notice. You just check it up. See if it is legal, and he is holding an agency. If it falls, the value falls. How can where is the mens rea?
That I'm taking. Since
Lordships have formulate the point and ask them to. Lordships have formulate the point.
My senior has not served a copy on.
No, I'll serve a copy.
My name has not been reflected.
That's right. You are absolutely correct. Yeah, that's Your name will be reflecting, he will supply a copy. I'm formulating the question and just answer it. I'm issuing notice. And it's returnable short date. Write down. What are you asking for?
Bail.
Bail. And what the trial court has rejected the bail?
Yes, sir.
By the order dated 16/10/2023, the designated court under OPDI Act Cuttack has rejected the bail application of the petitioner in CT case number 124 of 2023. The petitioner is, you are appearing for Mr.
He is engaged. He is engaged.
What have you written? Yes. The petitioner is in custody since?
Since
17/11/2023. 17/11.
17/11.
Mr. Milan can go briefed by Mr. Nidhikant Mishra for petitioners submits that the petitioner is running an agency or what how do you express it? Agency or
he is an agent of
authorized agent.
Authorized agent of
Yes World.
Yes World.
Dealing authorized agent of Yes World dealing with this cryptocurrency. Cryptocurrency. He
and the office
he has
company
relied
has
upon cryptocurrency. He has relied upon the judgment of the Honorable Supreme Court. It's not reported. Why don't you give citation?
I'll give you that.
Reported in so and so citation. So he will give. Relied upon para 176, page 176, para 6.171. 17. We reset. Right now. Mr. Kanbo submits that since dealing with the cryptocurrency, he held to be legal and well within the framework of RBI guideline. The petitioner being an agent of being an authorized agent cannot be saddened with the liability for loss of cryptocurrency in the floating market. Therefore, no criminal intention could be imputed to the petitioner for having dealt with a legally permissible cryptocurrency agency. Mr. Bhuya appears for the opposite party, states that he has received the copy today, and he would examine the issue in the light of the judgment of the Honorable Supreme Court, returnable.
I filed an IA. Also let them take
Issue notice on IA as well.
On medical grounds.
What is the medical ground?
He actually is in jail hospital. So what I am saying is, if he is transferred to any hospital like Apollo or anything, at his
what is the disease? And all big. The problem is all big shots when get arrested, they are ill. They are ill. They go to hospital.
If a criminal liability is imputed to him, certainly.
And he is a married man dealing with, and he can very well be in the hospital. According to I will issue notice. I will not get into all this thing. Let us give a short date so that I deal. If this is to be true,
yes,
then you are entitled for bail.
Yes, sir.
Why hospital and all?
Exactly. Yes. 4th, I won't be there. Any date after 4th.
He needs
2 weeks.
Let it be 14th. 14th. Till then, just see if he is not well, take care of him.
Yes. Miller, we have the SCB, which is AIMS plus. We can provide better facilities than.
Where is the IA, Mr. This is IA. What have you said?
Miller, I copy has not been served.
Also.
No, what is the disease you have?
This is heart ailment, sir.
You have not written anything.
Psychological, well, he is totally depressed.
Psychologically imbalance and depressed.
Imbalance and depressed, Malas. Now this is a.
Well, then nothing, you haven't said anything.
He's following his.
My
He's
honor
following his.
is more depressed than anybody in the world. We got with so many well.
Mr. Bhuya will be also now depressed looking into the volume of the paper. I'll not say because in the application you haven't said anything.
Well, I'll take his document. I'll give it. Like
You should
next
have,
day.
you should have placed something on record so that I.
Malas.
Anyway, he is there.
Yes, well,
He gave
he'll take care.
instructions so that at least.
He's fair enough, Malas. He'll take care in the interagnum, Malas. 14th I will press.
Very
14th we will press the main application.
Yes.
Can it be 9th, Malas?
Night.
Oh, 11. 11?
Monday. Monday.
Sunday.
Monday absent. No,
Difficult, no, let it be 14th only because lot of.
My lord.
It can't be heard unnecessary.
Yes, my lord. Subject to your lordship's convenience.
Yes. 25.
May I please, ma'am? I am
Yes.
I am in VC from Sambalpur, my lord.
Yes, no problem. You tell me.
A case under
What is
section
it?
302, 201, 34, 120B IPC, Your Honor.
Yes, notice CD called for. Yes.
Your Honor,
Let us see this 302. Let us see. Let the CD come. We'll see.
let me submit, Your Honor. In this case, charge sheeted.
Even if you submit, I'll do the same thing. Instead of wasting time, let us see the CD. Okay, let him bring. It is a 302 case.
Obliged.
CD has to be seen. Okay.
Obliged.
Yes.
26 not pressed, my lord.
Not pressed.
Already reasonable under section 167 clause 2 default.
Not pressed.
May I please issue lot similar. May I please issue lot similar. But this is a case for the commission of offense under section 20B2C 2529 NDPS Act Millard, quantity of ganja millard slightly more than commercial quantity. That
How
is
much?
millard 20 kg 480 grams
20
millard.
kg. Possession. From your possession, it is recovered.
Yes, prosecution allegation millard. I am coming millard.
What? Allegation only. 20 kilo.
20 kg, 400 grams, my lord.
No artist.
20.481 kg of contraband was recovered from the petition. Recovered from the petitioner. Grant bill subject to verification.
If
Similar type.
cases are pending, that not carried.
Subject to the petitioner, subject to the verification that as to whether the petitioner is involved in similar case, similar nature of cases or not.
Oblige your lordship.
Okay.
28.
May I please, your lordship?
Yes.
But offense under section 363 and 34 IPC, my lord. 363, 34 IPC.
Yes.
Kidnapping is a minor doctor, my lord.
Only charge sheet is filed.
No charge sheet,
No,
but custody, my lord.
Minor.
The victim is recovered, my lord. Very late.
6-year child. 2. We should notice CD called for. Yes.
I beg your
30.
30, may I please, your lordship? The 302 matter and petitioner inside custody since 11/12/2022. CD may be called for.
CD called.
I beg your lordship pardon, Lord. I am appearing for the informant in item 30, my lord.
30.
CDS.
ଆପଣ appearance ଦେଇଛନ୍ତି. I can get appearance of the I can. Yes. Okay. 29.
My name Bhavani Shankar.
Kaagaz de din.
29 appearance, I have 20 answer.
Appearance of the. Yes.
31.
May I
Yes.
please, your lord? My lord, the
Madam.
petitioner has challenged the bail rejection order passed by the.
What are the offences?
My lord, offences are under section.
376D.
My lord. 4 persons are there.
D, my lord.
394.
376D, madam. Gang rape. So CD called. Issue notice, it's called. Let us see. Let us see 164 statement at least.
With that also medical examination report of the victim.
Everything will come.
Everything will come.
My lord, I pray for day after tomorrow. I file a for interim bail. In the meantime, petitioner's sister marriage in 12th March. I have enclosed the tomorrow, my lord. I am ready to file.
Where is your application?
Ready coordinator type karo ଦେଇଛନ୍ତି ଦେଇନି କାଲି ପଳେଇଥିଲି ସ୍ୱର୍ଗଦ୍ୱାର ପ୍ରେସିଡେଣ୍ଟ ତା ଭଉଣୀର ବାହାଘର କରାଯାଇଛି 12 ତାରିଖ
ଏଟା ଗୋଟେ ପ୍ରିଣ୍ଟ କରିଛନ୍ତି ନା
ନା ଅଛି ସବୁ ଯେ ମୁଁ ଏକାଥରେ ଯୋଡ଼ିକି ଦେବି ବୋଲି
for the purpose of annexure printed only one
ରଖିଛି ଦେଇଛନ୍ତି ସବୁ ଦିଟା କାର୍ଡ ବି ଅଛି
verify କରନ୍ତୁ ଭଉଣୀର ମ୍ୟାରେଜ forget about your application let him verify କେବେ ଅଛି ମ୍ୟାରେଜ କହିଲେ ଆପଣ
12 ମାର୍ଚ୍ଚ 12 March.
Land Council for the petitioner says that the marriage of only sister, or you have any only sister. Marriage of his sister is fixed on
12 March 2024.
He has placed on record a invitation card. Invitation card and invitation card which is taken on record. Copy of invitation card is given to Mr. Ragada for verification. Verification. Leave the matter on. Bar
tomorrow, day after tomorrow.
Not day after tomorrow. 6, 7. Verification करेंगे ना verify कर देखो तो through ISC verify through ISC अपना you give the entire set of the copy ठीक है forget about your application marriage is there you will get it what is the offense by the way
offense 493
और चलो तो फॉलो तो 7 तारीख की
मैंने 417 493 294 और 506 में ना 33 टा मुन्ना
verify करो तो yes
may I please your lordship my offense under section 20B 33 my lord
मिथुन कुमार साहू
my lord
yes
22 kg 100 ग्राम गंजा my lord
हाँ 22
no artisan 22 kg one
same order जो करते हैं ठीक है 20 kg वाला same order करते हैं
okay
granted bail subject to you are involved or not
no
फक्त से दिखा we will verify and if you are involved you are not given if you are not involved you are given okay report
May you please lordship. Lordship, it's a case of 395 IPC lordship. Allegation against allegation is one Sudamna along with 2 unknown person obstruct the informant and taken away cash of rupees 2,35,000. In the meantime, the principal accused Sudam has been released on bail by this honorable court. Lordship, condition 5 deposit of cash of rupees 50,000 each.
same order कर दी
Lordship, Lordship, same order. Lordship, it is a cash of rupees 50. Lordship, cash of rupees 50,000. But as per seizure list has been 2,400 has been seizure from the present petitioner. Lordship,
2 lakhs you have taken 2,500.
Lordship, as per seizure list, 2,400 seized from the present petitioner. Lordship,
you will pay this much only. That's what you want.
Lordship, kindly consider 50,000.
You are in custody since.
Custody since 6/1/2024, Lordship. 6/1/2024.
2024. The first paragraph, second paragraph. The allegation against petitioner is what is the allegation?
One Sudam along with 2 unknown person obstruct the informant and taken away cash of rupees 2,35,000.
Sudama Naik along with the 2 unknown persons, including the petitioner, have abstracted the informant and forcibly taken 2,35,000 from the informant, and which was kept in the motorcycle dicky. What is your name?
Anita Sahu.
Anita Sahu, counsel for the petitioner, hands up order dated 22/2/2024, passed by the coordinated bench in ABPL number 479 of 2024. And submits that the main accused Sudhama Naik has been enlarged on anticipatory bail by the coordinate bench, subject to the condition that subject to deposit of 50,000 rupees cash. Yeah. And she submits that his client, her client, is in custody since 6/1/2024. He has applied for the grant.
No case. No.
Obliged.
He is already
Regular.
regular bail. Why 100?
Obliged.
Yes.
35.
On behalf of Mr. Rai, may I please, Your Lordship?
Yes.
Madam, the present petition in custody since 6/11/2023. Your Lordship, kindly have a look into the annexure to running page 6/11/2023.
Okay. What is the offense?
Offense, my lord, 376 to N 294 323 506.
Pokso.
Pokso. Your Lordship, kindly have a glance on the annexure.
That is the reason the cost is less. I would have seen you, I would have imposed.
Difficulty whether Mr. Panda is here, but that is the depositor are not getting their money. But his junior pay may have.
Oh, bless.
37.
Yes.
This is my please, my lord.
Yes.
This is a case, my lord, where the allegation against the petitioner is one
Offenses are
307 506.
Oh, what is the bail? Huh? What is the injury?
Yes. Injury is on the right leg of on the knee portion. There is an injury.
Okay.
Not in
And
the
he is released from the hospital.
Yes.
You are in custody since
24th December 2023.
24th
December 2023. And the co-accused persons,
Although
my
I
lord,
have not received the case there, but in fact in the page 12, second paragraph, they mentioned that discharge certificate is yours. Your personal mark that
discharge ಹೇಗಿಲಾನಿ ಗೋಡ್ರೆ ಮಾಡೋದು
that is mentioned. That is mentioned.
the co-accused, my lord, they have also
That is
released
mentioned.
case, counter case.
Page
What
12,
is what is your name?
Is Akshay Behra.
Property since 25/23, the discharge certificate of the injured, but the court below written. Was admitted AC Medical College Hospital and discharge on certainly 3 fracture wounds on each person.
Fracture wound. Right now. The allegation against the petitioner is an accused in so. The allegation against the petitioner is that he, along with how many of you? How many accused?
Two others. That is one.
One Rakesh Guru. On 24/12/2023 night, one Rakesh Guru called the informant over the phone, and he, along with the other accused persons, have assaulted the informant's brother mercilessly. As a result of which, the brother of the informant received what injury?
3 fracture injury.
3 fracture injury in his leg. The victim.
May I say in her person, madam, in his person.
In his
person.
person.
On his person.
In his person. And the victim had already, victim was treated, and he is now, he was treated. It is further alleged that the accused persons were holding deadly weapon.
Iron sword.
Namely sword. No, holding sword. Accused persons were holding armed with sword. And the shifted to hospital Bhubaneswar. From there, Medical College, and so the case. There is the report of statement of the accused and switch over to the incident. The petitioner is in custody since 25/12/2023. 23. The petitioner approached the Learned Court below for grant of bail, regular bail, since he is in custody from 24/12/2023. The 24/12/2023. The Learned Court below, why did its order dated the Learned Session says, why the order dated Session Judge Kurda at Orissa by the order dated 24/1/2024 rejected his bail application inter alia, stating as under. ये 12 number page 12 peruse the record. Peruse the record till execution at last. Last. Mr. Ragada IPS for the state submits that the allegations are serious in nature, and the trial court has rightly rejected the bail application. The investigation is going on. How much time will you take? FIR was lost when?
FIR was on 24th, madam. On 24th.
The FIR, although the FIR was lodged on 24/12/2023, the investigation is moving in a snail's pace, and the petitioner is in custody since 24/12/2023, taking into consideration the aforementioned granted bail.
One concern
And however, it is directed that the petitioner shall cooperate with the investigation without fail. Non-cooperation of the petitioner in the investigation process will entail cancellation of the bail. Yes.
39. May I please your lordship?
Yes. 30?
38. May I please your lordship?
39. Yes.
Your my letter. Case is under section 20B2C of the NDPS Act. And the petitioner.
What is the recovery?
Pardon?
Recovery.
No, that is no recovery from petitioner. Case is that two persons came in a motorcycle. That is the prosecution case. Two persons came in a motorcycle. They were intercepted by the police. And they disclosed that another vehicle is coming. After some time, a vehicle came. From that vehicle, a person was apprehended. In that vehicle, contraband article, ganja was there.
How much?
Pardon?
How much?
1 quintal.
1 quintal. Okay.
So this petitioner is the prosecution case. He and another person, he was driving. Another person was pillion rider of that motorcycle. So after some time, that vehicle came. So he neither from his conscious possession, nothing. Neither he was just driving this. Yeah.
Yes.
That is the case.
My lord, this petitioner was escorted to the contraband vehicle where the ganja has been seized, and one of
custody since
12/9/2023, my lord.
11/9/2023.
Charge sheet has been filed.
That's it, my lord. Yes, my lord. Yes, my lord.
Charge sheet has been filed. Just check it out.
No, my lord. My lord, I may pardon, my lord. Charge sheet regarding the charge sheet, my lord.
Right now, the allegation against the petitioner in the FIR is that the petitioner and the other pillion petitioner was the pillion driver. No?
Petitioner was the petitioner was driving and
petitioner was riding along with
another one was the Angad Rana was pillion rider.
Angad Rana
was the pillion rider
in a motorcycle, and the police has apprehended them. They have disclosed to the police that
Mahindra Bolero vehicle is coming.
Mahindra Bolero vehicle carrying contraband is coming behind their bay. and subsequently the Bolero vehicle was apprehended by the police, and contraband ganja to the 1 quintal contraband ganja was recovered from the vehicle. Then counsel petitioner submits that the petitioner nothing is recovered from the petitioner's conscious position,
My lord,
and he is in custody. 1 minute, he is in custody since 12/9/2023. 2023. Therefore, he is entitled for bail. Bishop Rahul appealing for the state submits that the investigation.
my lord, I may be pardoned, my lord. The petitioner rider of this petitioner having criminal antecedent, my lord, with same nature of allegation.
Rahul appears for the state and submits that the investigation is still on, and the petitioner has criminal antecedent. Let Mr. Rahul place on record the charge sheet and the criminal antecedent of the petitioner by next date of hearing. Leaves the matter on 15. Yes.
May I please, your lordship? My lord, here in this case, there is 3 bail applications, and my lord, initially the FIR registered on 302 and 34 of the IPC, then it's turned to 302, 427, 435, and 34 of the IPC, my lord. That is
custody since
my
My
lord.
lord.
CD has to come.
There no, my lord. CD has not come.
Call for CD.
Yes.
302. CD has to come.
Right.
Yes. How many bail applications you have moved?
My lord, there are
3
3
bail.
bail applications. Total 9 charge-sheeted accused persons.
You are in, all of them are in custody since?
All, my lord, 1 person surrendered voluntarily, Hemsagar, last bail application. He surrendered on 3/1/24, and others arrested on the same day, 18/9/23.
Let us. Okay.
Of
Next.
May I please, my lord?
My lord, alleged offences are, my lord, under section 420 and 406 of IPC, my lord.
What have you done?
My lord, I am in custody since 3/10/22. Allegation as per FIR is that on 2014, the informant approached the present petitioner that he was looking for a residential plot at Bhubaneswar, my lord. So the present petitioner introduced the informant to one Chandrakant Jena, who is the MD of Odisha Land Infra Private Limited. So after selecting a land at Chandaka, the informant paid the agreed amount of rupees to the tune of 15,25,000 through check in favor of the landowner.
What is the stage of investigation?
My lord, as per CD has not come, my lord. As per rejection order, my lord, there is the prima facie evidences are available, my lord. So your lordship,
How many cases are there with you against you?
My lord, I got instruction that 7 antecedents are there. I am on bail and all are remanded case after this case. My lord, fact is that in connection with EOW PS case number 14 in 2022, I have been arrested in 3/10/22 and thereafter remanded in present case. In present case. And thereafter, my lord, since 7 cases are there, I am already on bail in each of the cases. I am the introducer.
Mr. Rahul, get information how many cases are there, what is the state, and whether charge sheet is filed in this.
Charge sheeted, my lord, charge sheeted.
Charge sheet is filed in this case.
Yes, my lord.
In this case, charge sheet is filed.
Yes, yes. But charge sheeted on 6/10/23.
Call for the CD and to verify the antecedent of the petition. Please on.
My lord, date may be fixed.
Date will be fixed. 2 weeks after. Fix it on 22nd.
22nd.
Yes.
42.
My lord, initially FIR has been registered against unknown person, your lordship. Offense under section 20B2C of the NDPX Act, your lordship.
22?
20B2C. Amount is 95 kg, your lordship.
95.
My lord, initially FIR has been registered against two unknown persons. Prosecution case is that the IICO police suspected one auto rickshaw presence of ganja, your lordship. Chased the auto rickshaw with his team, and after some time he detained the auto rickshaw, but the persons who were present inside the auto rickshaw, they fled away, your lordship.
My lord,
And from the auto rickshaw,
as per rejection order, my lord, this petitioner has apprehended with this auto, my lord, Bajaj auto, my lord.
no, my lord, nothing. No, there is no evidence, your lordship.
Ambulance.
I am, ma'am, kindly permit to submit. Thereafter, he will submit. I am, my lord. The occurrence took place on 8/9/2023. The ISC detained the auto rickshaw, and from the auto rickshaw, from 2 bags, 95 ganja has been seized, your lordship. Kindly see the FIR against unknown persons. There is no known person, your lordship. Thereafter, your lordship.
You are apprehended from the spot.
No, my lord. My against me allegation is that I, with another Surya Kumar Sahu, were escorting the auto rickshaw. That is the prosecution case. Forwarding report is saying so, your lordship.
Who was riding the auto rickshaw?
Nobody was apprehended.
Automatic it was going on.
No, the persons who were present inside the auto rickshaw, they fled away. And against me, I was forwarded to the court with allegation that I and one Surya Kumar Sahu, the two persons, were escorting the auto rickshaw in a Bolero vehicles behind the vehicles of the.
You are in custody since?
My lord, I am in custody since, your lordship.
Pardon, my lord.
The same day you got trial.
He is right, my lord. He is right, my lord. I may be pardoned. Yes, my lord.
My lord, 13/12/2023, and more interesting things in this case, your lordship. Initially, your lordship, the present petitioner was arrested in Omabna PS case, number, your lordship, 276 of 2023 on 12/12/2023, your lordship. And in that case, he was arrested. Release order was passed on 12/12/2023, and on next day morning, that is on 13/12/2003, 7:30 AM, he was released on bail, your lordship. And 7:30 AM, again he was arrested in another case, your lordship. That is Omabna PS case number 276 of 2023. And in that case, same day he was released on bail, your lordship. On 13/12/2023, evening 4:30 PM, he was released on bail. And again, he was arrested on same day, your lordship. In this case, intentionally, my lord, in this case, the present petitioner was roped, your lordship.
There is same
One after another.
Investigation may be there, my lord. So your lordship may kindly call for CD and say, then it is better.
But what is this? 7:30 he released on bail. In one case, you apprehended him in another case. Again, he is released on the bail on the same day in the evening. Again in the
My lord.
case. What is this?
My lord, what my learned.
One day twice he was arrested, your lordship.
My learned phrase is submitting that he is remanded in different other cases, my lord.
Yes, that is also one aspect, your lordship.
This is how you.
While I was arrested in one case, they should mention all the cases which were pending against me, but they have not mentioned about pending of this case against me, your lordship.
Anyway, CD, you call for the CD, let us see, and give it a date. Let us count for the petitioner submits that to, he was arrested in which case first?
My lord, first
Where
he
he
was
got bail?
arrested in Omabna PS note 235 of 2023.
Tell properly so that.
Omabna PS case number 235 of 2023.
But here this case is 181/23.
1 minute. He was granted bail and he was granted bail in that case when he was released from the jail custody at 7:30 AM.
Yes, Lord.
7:30 AM in the morning.
My lord.
He was apprehended by the police from outside the jail. In case number, in PS case number?
PS case number 276 of 2023.
In the said case also, he was enlarged on bail on the same day.
Yes, Lordship.
On the same day. When he was released from the jail custody at 4:30.
4:30 PM.
At 4:30 PM.
My lord.
The petitioner was again apprehended.
My lord.
In the present case.
My lord.
Present case. a present case. The allegation against the petitioner is allegation against the petitioner in the present case is that he was escorting a
Bajaj
auto rickshaw, Bajaj auto rickshaw, where from the contraband ganja of 96 point
95 kg, 190 gram.
gram of ganja was recovered, and the auto driver escaped, fled away from the spot. Mr. Rahul appearing for the state submits that seeks time to produce the CD in the case, adjourn the matter. I've recorded so that it is easier. Yes.
May I please, Lords? 20B2C deals with 29 of the NDPS Act. Here, my lord, date of occurrence is 19/6/2023, and this present petitioner was arrested on the same day, that is 19/6/2023, and in the meantime, charge sheet has already been filed on 30/12/2023. And my lord, that ganja seized 4 quintal 17 kg of the ganja was seized. My lord, here the prosecution allegation as reveals from the first information report that the escorting party, my lord, that the informant and other police personnel, they were on patrolling duty. They got reliable information that some persons were coming, escorting the vehicle, and one Bolero pickup van is coming loaded with some contraband article. Thereafter, my lord, they hide themselves.
So CD, call for the CD.
Yes, ma'am.
Call for
City and criminal
criminal
antecedent.
antecedent.
Here, my lord, allegation that the present petitioner is driving the Bolero vehicle, and the escorting persons, my lord, they fled away, and the persons who was the occupant in the vehicle, who was driven by this present petitioner, he also fled away. And this innocent
conscious position.
That is right. But my lord, I am the driver, my lord. But the
Whatever.
owner and other persons, they fled away. Driver, my lord, for some amount, that is the salary or that is the wages that he is
That
engaged.
will be tasted. You are in custody since?
My lord, I am in custody since 19/6/2023. Persons who is the, my lord, owner, and the persons who are escorting, my lord, that is right. They have not conscious possession. But
conscious position is
my lord, I am the driver. I have
whatever
my
driver,
lord.
whatever that is.
As to let CD and criminal antecedent may
Let
kindly.
us see.
My lord.
Recovered from your position what? 44, yes.
May please.
Yes.
This is in custody since 15/5/23 minute. Charge sheet has already been filed. And
Offense?
76/1 and 506 minute. 76/1 and 506 minute. The victim is a married lady. The petitioner also both are married. They had relationship previously, the transaction of marriage from.
Where is 164?
My lord, there is a 164 statement, very short, my lord. Your lordship may kindly have a glance.
Let him read.
Let him read.
Let him read. Anybody can read.
Done.
Read it.
My lord, ଏତିକ ତାରିଖ ଦିନ 3ଟା ସମୟରେ ମୁଁ ଜଙ୍ଗଲକୁ ପତ୍ର ନେବାକୁ ଯାଇଥିଲି। ସେତେବେଳେ ଜୁରିଆ ମୁଣ୍ଡା ପଛପଟୁ ଆସି ମତେ ଜଙ୍ଗଲ ଭିତରକୁ ଟାଣି ନେଲା ଏବଂ ମୋର ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ମୋ ସହିତ ଫିଜିକାଲ ରିଲେସନସିପ ରଖିଲା ଏବଂ ମତେ ରେପ୍ କଲା। 164 is available, my lord.
What is that? What's
My lord,
read it.
that 1/5/23 ଦିନ ମୋର ପୁତୁରାର ବାହାଘର ଥିଲା, ମାତ୍ର ମତେ ଥଣ୍ଡା କାଶ ଓ ଜ୍ୱର ହେବାରୁ ମୁଁ ଘରେ ଔଷଧ ଖାଇ ଶୋଇଥିଲି। ରାତିରେ ଘରେ କେହି ନଥିବା ସମୟରେ ପ୍ରାୟ 10।
My lord, charge sheet has been submitted offense under section 341, 427, 294, 323, 325, 506, 34 IPC, my lord. In this case, charge sheet has been filed, my lord. Offense under section 341, 427, 294, 323, 325, 506, 34. Allegation is that, my lord, due to civil dispute, my lord, Piaggio Chiariro Bada Bhangidela dispute, the accused person assaulted to the injured my lord by means of a stick on his leg and head. And custody my lord since 18/12/2023 and charge sheet has been submitted 13/12/2023.
Yes, Mr. Rahul.
My lord, there is a last occasion your lordship has called for the injury report, my lord. That is one is left leg radius and right leg is tibia of fibula and the grievous is injury, my lord.
Grievous injury?
My lord.
Not 307.
No, my
No 307.
So then?
This is 325, 323.
320? Charge sheet has been filed, huh?
Yes, my lord.
Yes, my lord.
Oh. Petitioner is an
That's it.
accused.
321, 427, 294, 323, 325, 506, and 34.
Petitioner is an accused, is so and so, so and so. After investigation, charge sheet has been laid down by the police on
my lord 13/12/2023.
13/4/2023.
13/12. Iris bar.
23. The charge sheet is filed against the petitioner under section
341, 427.
Wait, everything you will tell or
341, 427, 294, 323, 325, my lord, and 506, 34.
30. The injury report on the victim indicates that the injuries are grievous in nature. Full stop. The petitioner is in judicial custody since 18/12/2023. 23. Huh?
Yes, my lord.
Would you like to say anything?
No.
I'm granting bail.
Yes,
Grievous
you
or-
are as well, say it.
Grant.
Privilege.
48.
22 lordship, 22 kg, 500 grams of ganja lordship.
22 kg.
Lordship.
Conscious position.
Lordship. 22 kg.
No, say, my lord.
Huh?
No, say, my lord.
No criminal antecedent of the.
Charge sheet is filed.
20, yes, my lord, and 22 kg, 500 grams, my lord. Yes.
They do same order. Yes. 49.
May I please your lordship? May I please your lordship? I am on BC, your lordship.
Pass out. 50.
Lordship, may I please your lordship? I am on BC, your lordship.
Yes.
50.
May I please your lordship?
Yes.
Item 49, I am on BC, your lordship.
49. Okay, 49. 1 minute. Okay, 49. Yes.
Lordship, the petitioner is inside the custody since 2/11/2020, your lordship. 2/11/2020.
20. Okay. What is the offense?
Your lordship, offense under section 498, 302 and 201.
302.
Yes, your
Okay.
lordship. In this case, charge sheet also submitted on 28/2/2021.
You are the husband.
Yes, I am the husband, your lordship.
CD has come.
Yes, my lord. Final form has been submitted, my lord. And the postmortem report and 161 statement of complaint, and as well as, my lord, the confessional statement of the victim for leading to the discovery of the weapon, my lord, and the 161 statement
What was
of
the weapon?
the son of deceased.
What was the weapon?
The weapon, my lord, at 7 Thenga, my lord.
Finger.
Your lordship, the deceased was recovered from the river, your lordship. And there
What
is
about
no direct evidence against
27.
it.
27.
That is the here the petitioner is entitled in the 27 leading to
And there is,
discovery.
my lord, I may be pardoned to mention, there is vital 161 statement of his, the one son of a deceased, my lord. I may read, my lord, if you lordship may allow to me. Mo Govinda Chandra Mahanti alias Bunty, mo Khodaji, 1 ଦଉଛି ମୋର ବାପା ରମଣୀ ରଞ୍ଜନ ମହାନ୍ତି ଦିସ୍ ପିଟିସନର ମୋର ବୋଉ ନିର୍ମଳା ମହାନ୍ତିକୁ ସବୁବେଳେ ବାଡ଼ାନ୍ତି, ବେଳେ ବେଳେ ଖାଇବାକୁ ଦିଅନ୍ତି ନାହିଁ। ମୋର ବାପା ମୋର ବଡ଼ ଭଉଣୀ ମୋତେ ମଧ୍ୟ ବାଡ଼ାନ୍ତି। ମୋ ବାପାଙ୍କ ମାଡ଼ ଯୋଗୁଁ ମୋର ବୋଉ ନିର୍ମଳା ମହାନ୍ତି ବହୁ ସମୟରେ ଘରୁ ବାହାରି ମୋର ମାମୁଙ୍କ ଘର ଜିଣ୍ଟ ଶାସନକୁ କିମ୍ବା ମୋର ମଉସା ଅର୍ଜୁନ ମହାନ୍ତି ଘରକୁ ପଳାଏ, ପୁଣି ମୋର ବାପା ମୋର ବୋଉଙ୍କୁ ବୁଝାଇ ଘରକୁ ଆଣେ। କିଛି ଦିନ ଭଲରେ ଚାଲିଲା ପରେ ମୋ ବାପା ପୁଣି ବାଡ଼ାନ୍ତି। 15-10-20 ତାରିଖରେ କୌଣସି କାରଣ ଯୋଗୁଁ ମୋ ବୋଉକୁ ଗୋଟେ ବାଡିରେ ପ୍ରବଳ ପିଟିଲେ। ମୋ ବୋଉକୁ ବଞ୍ଚେଇବାକୁ ଗଲାବେଳେ ସେ ମଧ୍ୟ ମୋତେ ପିଟିଲେ। ତେଣୁ ମୋର ବୋଉ ନିର୍ମଳା ମହାନ୍ତି ଘରୁ ବାହାରି ମୋର ମଉସା ଅର୍ଜୁନ ମହାନ୍ତି ଆଲିଆସ ଗଗନ ମହାନ୍ତି ଘରକୁ ଯଶପୁରକୁ ପଳାଇଲୁ। ସେଠାରେ ମୁଁ ଗୋଟେ ଦୋକାନରେ କାମ କଲି। ମୋର ବୋଉ ଜଣକ ଘରେ ରହି କାମ କଲା। ଗତ 25-20 ରେ ମୋ ବୋଉ ମୋତେ ମଉସାଙ୍କ ଘରକୁ ଡାକିଲା। ବୋଉ ଘରକୁ ଫେରିବାକୁ କହିବାରୁ ମଉସା ଗତ 26-10-20 ଗୋଟେ ଅଟୋ ଠିକ କରିଦେଲେ। ମୁଁ ମୋର ବୋଉ ସେ ଅଟୋରେ ଘରକୁ ଫେରିଲୁ। ଯେତେବେଳେ ଘର ସାମ୍ନାରେ କେନାଲ ବନ୍ଧ ପାଖରେ ଅଟୋ ରହିଲା, ସେତେବେଳେ ମୋର ବାପା ଆମକୁ ଦେଖିଦେଲା। ରାଗରେ ଗୋଟେ ଗଛ ଡାଳକୁ ଭାଙ୍ଗି ଦେଇ ମୋ ବୋଉକୁ ଗାଈ ଗୋରୁ ପରି ପିଟିବାକୁ ଲାଗିଲା। ମୋର ବୋଉ ଜୀବନ ବିକଳରେ ଚିତ୍କାର କରି ମାଟିରେ ଗଡ଼ି ଯାଉଥାନ୍ତି। ମୁଁ ଯେତେବେଳେ ମୋ ବୋଉକୁ ରକ୍ଷା କରିବାକୁ ଆସିଲି, ସେତେବେଳେ ମୋ ବାପା ମୋତେ ମଧ୍ୟ ନିସ୍ତୁକ ବାଡ଼େଇଲେ। ମୋତେ ଘରେ ଛାଡ଼ି ପଳେଇ ଯିବାକୁ ଧମକ ଦେଲେ। ମୁଁ ସେଠାରୁ ଭୟରେ ଅଟୋ ନେଇ ପଳେଇ ଆସିଲି। ମୋର ମଉସା ଅର୍ଜୁନ ମହାନ୍ତି ଗଗନ ମହାନ୍ତିଙ୍କ
You are not entitled to bail. Will you withdraw or I'll dismiss?
Your Lordship, the injury sustained prior to the occurrence, Your Lordship.
No. The injured witness, your own son is saying all these things. You have been torturing the entire family and beaten mercilessly to your wife.
Your Lordship, his death is cause of death is due to drowning in the river, Your Lordship. The assault was prior to that, Your Lordship.
Those are the defenses you have. No problem. Will you withdraw? I'll dismiss. So generally, if there is something I will give. There is nothing in this case. What to do? Your own son is defending you.
Last question, Your Lordship, also I have submitted that out of 27 witnesses, only 2 witnesses have been examined. That's why Your Lordship called for the report from the ADG, Your Lordship. That is the.
What is the state,
Your Lordship?
No, my lord, that has been called by Hon'Ble Court, my lord. The status report of the trial, my lord, it has been called by Hon'Ble Court, my lord.
Lordship, already the petitioner inside custody.
My lord, here in
there is a report, man.
My lord, here in this case, there are external injuries, and the MO has opined that all the above injuries are antemortem in nature. Injury number 1, 2, 3, 4, 5, and 6 could have been caused by hard and blunt trauma, and are not sufficient to cause death of individual, neither individually nor in combination, my lord. But the MO has opined the cause of death is due to asphyxia as a result of antemortem in drowning. And as per the 161 statement of the accused, my lord, it is supporting to the prosecution, my lord. Clear cut case.
The cause of death is not due to the assault, Your Lordship.
Out of 28 charge sheet witnesses, 6 number of witnesses have been examined till date. Summons have been issued to witnesses for examination. The prosecution also directed to produce statements for the rest of the charge witnesses. Possibly, not the case is posted. The case was posted on 26th yesterday. What happened?
I have to take instruction. I have right now. I have no instruction. The counsel for the court will have to consult.
The report was sought from the court below. The 4th additional sessions Judge Bhubaneswar has submitted a report dated 23/2/2024, inter alia, stating that out of 28 charge sheeted witnesses, 6 witnesses have already been examined, and the remaining witnesses are summoned to be examined on 26/2/2024. And what is the present status of the case is not known to either the petitioner or the learned counsel for the state. Urgent the matter to appellation. Yes, next.
May I please, Your Lord?
Yes.
I am on BCML. 50. I am on BCML, Lord.
Yes.
Am I audible? Am I audible, man? Am I audible?
Yes, I can hear you. 307.
30. No such no such offense so far as the 307 is concerned. It is out of a complaint case.
Charge sheet is filed.
No, charge sheet is filed. There is no sign and symptom of any kind of injury to the informant. This is a case arising out of a complaint case. There was an agreement made between the petitioner and the son of the informant that the informant
No,
son
there is an FIR here.
arising out of complaint case, my lord, not FIR,
Arising
not
out of
police FIR.
complaint case. Okay.
Complaint case. That is a one complaint case. That is a complete false complaint case filed against the petitioner and the family members. And one of the accused person has been served a 41 notice in this case. On Ranu Padi, the wife
What
of
are
the
the allegations against you?
allegation against you that while the informant was sitting in her room, the family members of the petitioners, they went and they dragged her and they dragged her and tried to kill by pulling her pigtail. ତା ଚୁଟି ଧରି ଟାଣିଲେ ବୋଲି ତାଙ୍କୁ allegation ଅଛି. CD was called for on earlier occasion. Complaint case.
What is the
My lord, the accused petitioner has made the agreement with the complainant, my lord, and taken the huge money. And whenever the complainant has demanded the land as per the agreement, and then this petitioner is scolded and threatened for any dire consequence. So in this connection, my lord, there is 161 statement is there, my lord, victim and as well as her son, my lord. If you let's follow, I may read to this.
No, what is this? She has what is the allegation against exact allegation? The transaction and all is something different.
Yes.
What he has done? It is alleged.
His wife is not well and not coming for filing affidavit. Let's come 15 days time.
Please sheet after 15. Why is
Man.
give urgent, na? 60, na? 60. 66. Okay. No problem. Okay. Yes. Pass over item.
Item 1.
Item 1. Urgent. Yes. Item
3.
3. Yes. 313, Mr. Goda.
Relevance of the filing for the report from the PS matter and of the statutory entity. In fact, matter here the 315 is allowed and the depose in the court matter the accused himself matter. 315 matter. So, but other matter documents have no relevance with the case matter and they are saying that that is on the particular day there is cyclone. They may obtain the certificate copy and will produce before the court. One of the way general guidance from the police station matter. As the case is a fabricated one, my lord, there is defects in the general diary. That's why you find a fiction for that.
Have you have you confronted this point with the IO? Then
And so also they have not, the accused have not said that
you have not confronted this point. Then how can you?
Himself
necessary. Necessary. There are, Mr. Raghuda, have you examined all the 5 applications?
Well, only they are saying that different police stations on particular day general entry is required. That is there.
This is one. And other
all the 3.
all the
Fourth is the corporate report from the private news channel.
News channel, they will not produce what is this? Your defense evidence you have to bring. And insofar as the case that the general diary entries are concerned, you have not confronted with the with IO. You have not confronted. Ye koi jandi. Show me which 131 statement, 313 statement.
15 himself cited as different sources. As he told one.
आपण टिके देखंतु कोनटा कोटा एलाउ करी हबो टिके देखंतु. No, but then I have to read everything. And he's yes, I understand. See, relevancy you derive relevancy from the 313 statement.
He himself
Which 313 statement you want to discredit? You show me which question. Question number you tell me. What is the purpose of 313 AQ statement? Whatever evidence has been collected by the prosecution, everything is put to you. And you answer that. On that basis, you will lead your defense evidence. You show me 313 statements which are then why the evidence is not put to you, then why will you adduce evidence on that?
Well, that is required for their argumentation because my lord, entries are there is a discrepancy in the entries. That's why we find it.
Show me 313.
Private and depends one is one subscription and another subscription.
Come to page 10 of the 313. You read and assist. You don't expect me to read everything and try to find out a point for you. Which case diary, general case diary, according to you, is fabricated? Which one?
From 3/12/2021 8 AM to 5/12/2021. Another is my police station from 13/1/2022 to 51.
13?
1.
13/1/2022?
To 51.
That is why I'm asking you about 59, question number 59. Just see. Who is PW5? You prepare properly. You have not prepared. Prepare properly vis-a-vis the 313 statement which are relevant, you tell me. You say everything is relevant, he says everything is irrelevant. But you have to tell me if it is relevant, how it is relevant. You have to tell me, no, it is irrelevant. Then I'll have to examine everything to find out whether it is relevant or not. You have to tell me, assist me so that I can dispose it out. Not tomorrow, give a date.
Two minority, two general diary not required. If minority and see page 13, I
1-3.
the fourth person I will find with the prayer to direct the head and any authorized officer of meteorological center to produce people this follow the cyclone bomb one part.
It is consideration. Yes. Next. We'll see. Next. 6. Yes. PC Act. We'll see how it. But you prepare and come. We can't waste time in an application under 311 for 3 hearing, 4 hearing. You have to give proper assistance. Then only I can help you to dispose it up. Okay. Give a date. Yes. PC Act, you want question? Yes. Yes. What about petitioner number 2, wife?
The wife is working assistant teacher.
Assistant teacher, right? But disproportionate estate case of the husband, he is suffering. And under the aid of 109.
Both. And also one is a better also.
Who is a better?
The wife is also.
That's what I'm saying. What is the allegation against wife?
But in fact, my girlfriend has come up with another prayer note. That's it. He has though has couched it in that postment of the provincial orders. Lordship noted by page 9 is prayer notes that fixing the stipulated periods for in which one of the trial is to be concluded.
That is ordered 15/12/2020. The trial has already been reviewed. Witness Bobby Prahan, that is W4, has already been prosecuted. And the petitioner 66-year-old.
That is not a consideration. If the trial is going on, how? Why should I quash the cognizance order at this stage?
Out of 51 witnesses, 24
FIR lost one. Okay. The petitioners are facing trial for allegedly committing offence under section 13(2), read with 13(1)(e) of PC Act. The FIR was registered on 29/6/2013, whereas the charge sheet was filed on. And read with 109 IPC. Charge sheet filed on 29/6/2013. Counsel for the petitioner submits that despite the fact that the case more than a decade has passed, the prosecution is taking time, prolonging the. That is his submission. The prosecution is prolonging the trial. File. Then counsel for the opposite party contribute the fact that he says that the prolongation of the trial is partly attributable to the accused as well. Without going into the fact as to the reason for delay, the fact remains that the FIR was registered in the year 2013. And 10 years has passed by. It is expected that the trial court should do well to conclude the trial as expeditiously as possible. as expeditiously possible. With this observation, the petition is disposed of. Next. 25/5/2015. That's it. Okay. Yes. Yes, you are appeal. That's appeal. Yeah. 9. Where is by? Allowed. That was allowed?
Yes.
Have you asked?
Yes.
Okay, yes. Yes. Yes, madam.
For IPC,
Mhm.
here the petitioner has prayed for quashing of the FIR. Your Lordship, on last occasion, there was a notice to the opposite party number 2, who is the informant. The noting shows that there is a representation petition from opposite notings also.
Service is complete. Let's see. Opposite party number 2.
At flag 1.
Representation petition, what is this? Petition filed on the opposite party, so something the opposite.
Which one? Voter ଦେଇଛନ୍ତି ଆମକୁ କିଛି document ଦେଇନା
Allow the petition. Allow the petition in favor of the opposite party number 2 for this case. For which act of what is this?
Jemamani Das ଦେଇଛନ୍ତି କିଛି representation
She is the informant.
କଣ affidavit କରିକି
Jemamani has given an affidavit. Jemamani. She says that I can't come and allow the petition.
if she has prayed for then there is nothing Rosim request this yes yes
Who will verify this? Whether she has sent it or manipulated, who knows? Right on.
one copy may be given to
Pursuant to the notice issued by this court on 8/1/2024, the opposite party has now given a representation along with an affidavit inter alia stating that she cannot come to the court to oppose the petition. Rather, she says in the affidavit that the case may be allowed in favor of the petitioner. Since nobody appears for the opposite party number 2, the authenticity of the affidavit and representation needs to be verified. Accordingly, the IIC of which police station?
এটা হচ্ছে আনন্দপুর
IIC Anandapur PS may verify the authenticity of the affidavit and representation given by the opposite party number 2. Place a report on the next date of hearing. 90.
Obliged, Your Lordship.
Yes.
ଗୋଟେ କପି ସେଇ ତାର ଜେରକ୍ସ କପି ଗୋଟେ ପାଇଲେ ମୁଁ ସେଟା ପଠେଇଦେବି
Xerox copy ଦିଅନ୍ତୁ.
ମୋ ପାଖରେ ନାହିଁ. I just
Let's
need
say
to
court-
know
court-
by the list.
Mr. Maharaja submits that the photocopy of the representation and affidavit filed by the opposite party may be supplied to him so that he can get it verified from the IIC.
yes yes
Same may be given to Mr.
Obliged, Your Lordship.
ଜେରକ୍ସ କରିଦେବି
56. Adjourned.
57. May it please your Lordship. 57, Lordship?
Yes, 57.
Lordship. Lordship, my Lord was pleased to direct me to surrender before the court below on the order of 2/1/2024. Lordship, accordingly,
You sought 15 more days.
Lordship,
You have
Lordship.
sought further time 15 days.
no, I have surrendered and I am been incarcerated. I am been remanded to custody presently.
So what do you want?
Lordship, that is the whole thing.
Lordship has directed me to surrender before the court at parity with the co-accused which has been released on bail, who has also surrendered. Lordship, kindly have a glance on the paragraph 4.
Of paragraph 4 of the petitioner also argues.
Order, Lordship. Order dated 2nd January 2024.
Bench to persons without expressing any opinion on merit, the trial court may consider to be the application. The petitioner wants to surrenders in the same manner as then who can say no, I have said that I am not expressing any opinion.
Yes, Lordship. Yes,
you have the remedy. You don't
yes,
know
Lordship.
by the order dated. You can't keep on moving application after application.
No, Lordship, I am not keeping it. I am not applying
You
it.
You asked for further accommodation of 15 days. That also I gave. Now you are moving an application that he rejected. What is it? Shall you withdraw or I'll dismiss it with some cost?
No, Lordship, presently I am deprived.
Maybe deprived. This is not the forum. You can't keep on moving an application after application. Small indulgence is given by the court to help you out. Doesn't mean that you will take the court to right. Dismiss the application is misconceived. The same is dismissed with the cost of rupees 5,000 to be deposited. So.
No, Lordship, kindly.
No. I will not. Don't take the leniency of court to this level.
No, Lordship. I have also filed one bail application.
Bail application is 482 by way of an application.
But Lordship's observation can assist me to get the bail.
No. I have committed a mistake by giving observation. Therefore, you are taking two times you moved application.
No, Lordship, last
Don't
time
do
it
that.
was a mistake. Lordship.
Don't do that. Because of your conduct, the other people will get affected.
Lordship, I withdraw.
No, dismiss with the cost of 500. Nothing doing.
Lordship, I withdraw. Lordship, cost, it will be another burden to me, Lordship.
Let it be. Sometime I need to be harsh.
Lordship, I am in custody right now.
Let it be. Why are you trying your luck by moving application in 482?
No, Lordship, it is not. I know that Lordship cannot grant.
Twice I gave you indulgence. Still you are taking chance.
But Lords must know what is happening in the lower court.
Land Council petition seeks to withdraw the application. Same is withdrawn. Dismiss it. Yes. Next. Don't do that. Unnecessary.
58, nobody is there and copy not served.
Adjourned.
Madam.
May please your lordship. Honorable court, please pass to order, rightly order.
Yes.
Well, by mistakenly, I pray for a modification, my lord. There is a PS case number 2023 जगह 3 लिखी थी. कितनी केज का था? 12/6/2023 जगह 12/6/2003 लिखी थी.
What you have written? What you have written?
Order, my lord, order is पड़ी गई सो.
GR case ना?
PS case number 170 12/6/2023 जगह 12/6/2003 नहीं.
I know that. I understand it. But what you have written? No. Come to page 1 of your petition.
My lord.
Before I blame my staff, you said see. What is your petition? At the top.
My lord.
The matter relating to Mangalabag PS case number 0170 dated 12/6/2003.
My lord, I wrongly.
You have written what to do?
No, by mistake. Sorry, my lord.
I'll start taking action against my staff because he has committed.
No, I have wrongly.
In one place you are writing 2003, in the other place 2000. And
no, I have wrongly, man. Sorry, man.
Why are you so casual? I don't understand. The High Court level, how can you be so casual? In this is an application for modification of order dated 8/1/2024. In para 1, in para 2, in para 2 in the second line, 12/6/2020, 2003 is wrongly mentioned in place of 12/6/2023. 23. This application is allowed, or the order dated 8/1/2024 stands corrected in the aforementioned terms. Okay.
Oblige.
Okay. But you should be little careful. Yes. Yes, yes. No problem.
Maybe not. Last one, issued notice to the opposite party number 1, my lord. And in this case, the present petitioner challenges the order dated 23/8/2023.
Either use yes.
Last time I directed to issued notice to the opposite party number 1, my lord.
Yes. The whole opposite party.
62, 60. Private.
Somebody is appearing. Name is reflecting. Name reflecting.
List name.
His name is not reflecting. Reflect his name and list it somewhere. If the pursuant to the notice dated notice issued by this court on 3/1/2024, so and so appears for the opposite, enters appearance for the opposite party and files local Atnama. Since his name is not reflecting the court date, he is not present in the court. Name of so and so may reflect in the. Yes.
The IO once reported the seizure to the land and SDGM, and without the taking recourse of law, it disposed the property in presence of a executive magistrate Tahsildar, which violates the provision of CRP. So my lord was pleased to direct the instruction to obtain the land and state council to obtain the instruction. My lord was pleased to direct.
Yes.
Yes.
Yes. His case is the articles, seized articles were destroyed without following due process.
Yes.
You last time you said that it was done in presence of executive magistrate.
Yes.
And what is the procedure you have adopted? Yes.
That has been, he has given all instructions.
You have a report?
Yes, yes.
Full place.
Everything.
Give it to Mr. Mishra.
Yes,
Let
yes,
him
come.
examine.
Yes, I'll come
Yes.
after examining. I will come with a note.
Mr. Maharaj submits instruction report. What is that?
Instruction along with the order passed by the SDM.
Mr. Maharaj submits a written instruction along with certain documents regarding the procedure adopted for destruction of the seized articles
By the IO.
By IO. The same is taken on record. Copy is supplied to Mr. Mishra. Leaves the matter on service for further use. I'll
vote.
Yes.
The lordship fix up as you lordship fix after Lord.
Yes.
10th.
Yes.
62.
Grateful, my lord.
Item 62, your lordship. Mr. Mishra has some personal difficulty. Your lordship kindly take a next week candidate, your lordship.
The next week.
Yes.
63.
Deep problem.
May I please, Your Lordship? My lord, this application for quashing of the FIR and this FIR filing by a complaint case by the complainant, Your Lordship, absolutely on the face of the FIR, there is no case made out against the present petitioner.
Charge sheet copy
Yes.
Charge sheet copy
Yes, those
Where is the charge sheet?
Yes.
Where is it? Have you filed it? File it on record.
This is the original certified copy.
Certified copy I don't need. Photocopy. File.
Yes.
Photocopy of the land
Stop
counter
the-
petitioner submit that the charge
Yes.
sheet has already been filed in the present case. He seeks time to file, place it on record the copy of charge sheet. Let him, the photocopy of the charge sheet may be placed on record, leaves the matter for hearing.
Yes, my lord, I have served the copy on the State Council.
Copy of the
Charge sheet.
photocopy of the charge sheet is served on Mr. Maharaja. Mr. Maharaja seek instruction in the present matter.
My lord, a date may be fixed.
Oh, date will be fixed.
Obliged.
The senior counsel is there. Ask him if he senior counsel.
Mr. Mahapatra sitting here. Mr. Mahapatra is.
I couldn't see him because
No,
everybody is
no,
standing
that
in front.
is-
No,
that-
otherwise I would have asked for.
I'll wait.
Yes.
Wait, please, Your Lordship. Item number 64, my lord, because of delay in filing of the requisites, Your Lordship, the requisite not served to the OP number 2, my lord. Your Lordship may kindly direct the registry to issue notice to the OP number 2.
Are you enjoying interim protection?
There is no interim protection, Your Lordship.
No interim protection. Then you can take that liberty, no problem. Give that. Sometime you interim protection is given, then you do like this.
No, my lord, what happened, my lord, because of the uploading of the order, delay in the upload of the orders, I filed.
Okay. For the time.
Issue,
What do you want now?
Issue notice to the OP2, already filed the requisite, Your Lordship. Your Lordship may kindly accept the requisite notice.
Okay, requisites have already been filed for serving the opposite party number 2. Issue notice to opposite party number 2. Returnable.
Great. Your Lordship may kindly fix a date.
A date will be fixed, don't worry.
After 3 weeks, my lord.
After 3 weeks.
Great.
Lordship, I filed an application for modification at page 8, your lordship, of my IA. Instead of trial, that may be either before commencement of trial or charge, your lordship. That's
Sorry, which order you want modification? 12/2/2024.
Lordship.
Which paragraph?
Paragraph 3 at the second page, your lordship, last word.
Hmm.
At the stage of trial, that may be before commencement of trial or charge, your lordship.
Therefore, taking cognizance so far as the said offense is concerned. Cognizance vis-a-vis of 497 is set aside. However, in so far as the other offenses are concerned, the petitioner seeks liberty to raise all the points before the court below at the appropriate stage of the trial. Okay.
Trials more raise करियो नहीं, your lordship. Either at the charge or before commencement of trial हेले से charge रो benefit नहीं होगा.
I will not modify it like this. That this is what is the understanding.
Trials start from the date of issuance of a charge, framing of charge. So at the same time you file.
Opportunity, I will lost the opportunity of charge, your lordship, for filing an application to
That is
discharge.
why
That is why.
497 I passed. The
Yes,
other thing
Lord.
you have to face the trial. That is the idea.
But
You will move, thereafter you move an application at 227 and get it rejected, again file 482. That's your idea.
Lordship, there is a provision, there is an opportunity, due process of hearing, that is why
Opportunity
before
avail the cognizance says. So you should have waited at the time of framing of charge. You should have argued everything. At the cognizance stage, you jumped in and argued everything. So therefore, I have taken into consideration everything. 497 is not made out. I took it out. And insofar as the other offences are concerned, go and face the trial. So therefore, that is the risk of coming at the cognizance.
I apologize, your lordship, charge opportunity.
The petitioner has moved the application for modification of the order dated 12/2/2024. He submits that although the liberty is granted to the petitioner to raise all the points before the court below at the appropriate stage of trial, but although appropriate stage of trial, all the court, appropriate trial. However, the said observation is taking away his right to move an application for seeking discharge at the time of framing of charge. So he may be given liberty to raise all the points at the time of framing of charge.
Yes.
Such modification due.
Obliged,
But deliberately I did it.
ऐसे जान दो. This court.
Obliged.
Seven.
67, may I please, Lordship? I have filed for modification of order dated 6
What is
February
happening here?
2024. Para 2, Lordship.
Yes.
NBW issued on 6th January 2024. 26 age.
To 6.
Six,
I don't understand.
Lordship, another, it's a 6 January fresh NBW issue ହେଇଥିଲା. Earlier NBW issue ହେଇଥିଲା 17/12/2003. ସେଇଟା kindly Lordship may be recorded. ନାଇଁ ସେଠି JMFC ରେ ନଉନାହାନ୍ତି, ସେ କହୁଛନ୍ତି accept କରୁନାହାନ୍ତି earlier. ସେଇଟା may be recorded.
Where from they got this date? I'm just.
Annexure to Lordship of the main petition.
Have you mentioned anywhere? This date 26.
26 para 2 ରେ ଲେଖା ହେଇଛି. Order. Steno mistake.
Who has done it? Everywhere it is 6. You correct it and put it before. Everywhere in the petition it is 6. Oh, correct.
Lordship, another earlier NBW issued 17 December. Lordship, JMFC accept କରିବେନି ସେ ପୁଣି modification ପାଇଁ ଆସିବ. ସେଇଟା may be recorded. Earlier NBW issue 17 December.
NBW has gone now. Press NBW. Press NBW I can check.
High Court order କିଛି ନାହିଁ.
Accept there was NBW. It was not executed. Press NBW issued. Press NBW I passed. What is the problem in it?
JMFC ସେ ବୁଝୁନାହାନ୍ତି, ପୁଣି ଆମେ NBW ପୁଣି ଆସିବୁ modification.
Nobody asked.
Recorded just.
In the application, the petitioner has moved an application for seeking correction. The typographical correction occurred in para 2 of the order dated 6/2/24. 24. Instead of the order is in the last line of the para 26/1/2024 is written instead of 6/1/2024. It is accordingly corrected. Then comes the petitioner further submits that earlier NBW was issued
17th December 2003.
against his client on 17th
December
2003. The same was not executed, and finally NBW was issued on 6/1/2024.
Press will. Lordship, time may be extended.
Time is already fixed.
Time 25th.
In view of the aforementioned clarification, oblique modification, the time granted to the petitioner to appear before the court on or before
Order is 25th February.
On before 25th
February.
Time fixed on or before 25/2/2024 is extended up till 20
March.
After 20th March. August. इसको लेके आओ. ठीक.
68.
Yes.
Mr. Manasan, if appearing for the petition, my lord.
Nobody is there.
The opposite party counsel is there. I for the
Urgent petitioner is not there. Why should you? April maybe last. Yes.
70.
Yes.
70, my lord, I pray for an adjournment. Next.
Okay.
71.
This matter, my lord, lordship directed me at least to file all the compilation, starting from the application up to the FIR, there is a protest petition. Protest petition, there is an enhancement. Developing the whole case, the cognizance was taken. So that is under challenge. Lordship wanted how many cases she has filed. So she has also filed before the charge sheet one revision application before the Honorable Court. That also filed a divorce petition. In all these, the facts that is narrated, the first initial cases are identical. But so far the development is concerned, that is developed after 2.5 years. So Lordship wanted all the papers. Along with that, second allegation was that she has not been examined 161. That copy also I am filing. So the entire compilation I am filing, the Lordship's perusal, and the other side is to, I think.
My Lord, I'm appearing for virtual board. My Lord. Yes, sir. Copies of this document has not been served on me. Let it be served on me, my Lord. The matter may be taken up on some other date.
My Lord, these are all their documents.
No, that's true, my Lord. But I need to.
That's correct, my Lord. This is their petition where they are having different facts, and in the protest petition they have developed it. That's the whole allegation.
That's true, my Lord. But I need to see what documents are being filed so that I can consult my client.
The Mr. Mahapatra, senior counsel appearing for the petitioner, has filed a compilation as directed by the court.
Actually, the direction was to them also.
On 9/2/2024, 9/2/2024. The copy of the same may be supplied to Mr. Rai, appearing for the opposite party number 2, and the state counsel, Mr. Maharaj.
It was directed at least to file the charge sheet. And the entire quest record also. Because what I have obtained is 161 is the certified copy.
Copy, maybe supply a copy.
Authority directed the state at least to file that police record.
Meanwhile, Mr. Mahapatra, Mr. Maharaja seeks time. Mr. Maharaja seeks time to file the copy of charge sheet. In the meanwhile.
Anina, Anjubra. Anjali.
Everything is there.
File कौन तो ना देखिए तो.
Charge sheet adi din.
Charge sheet copy to file करो.
Charge sheet हमें file करूँ चुन ना नहीं. Lordship wanted the 161 recording. That's whole case diary.
Statement is
case diary.
Yes, yes.
It is there.
Yes,
you please file so that we can see the 161 statement what he has said and how it is improvised.
Yep.
You're right. Yes, right.
That is the
But
yes,
that's all.
area where we have to.
Right. All 161.
His entire case is in the earlier, when the FIR was filed, nothing was there. Charge sheet, nothing was there. Closure report is filed. When the protest petition was filed, he has improvised everything.
Yes, I got
given.
Yes, I got
New story is given. So therefore, I want to see the 161.
Yes, that is why you are also called for the entire statement.
Fine.
And I'm giving
Please, the matter on.
Can it be my order first week?
First week.
On 5th or 6th?
6th.
6th. My lord, there was a direction that in the event I move an adjournment application.
That direction is still continuing, my lord. My lord, may I pray any time after 15th, my lord?
No, before 16th I am saying. 5th or 6th.
No, anytime after 15th, my lord. I've got some personal difficulty. Anytime after 15th, my lord.
Give after 15th, you will
My lord, that's the problem, my lord. 15th, then in that case, my lord, have it on 19th? 18th or 19th? 19th would be okay.
19th? And the same order.
19th will be okay?
Yes, yes. Thank you, sir.
Same interim order.
Copy served on all parties.
Copy is already same interim order.
Obliged.
My lord, as per lordship's direction, all the petitioners, except 2 petitioners, all the petitioners appeared before the IIC Chandpur police station. But in fact, some different IIC Chandpur police station got some difference in between the Aadhaar card and a name of the petitioners. Only 2 persons.
Let him say so.
My lord.
Now we have already received the instruction. Question is that, my lord, the IIC has given all the documents, and here says some of the accused persons, their name not tallied with the Aadhaar card affidavit. So that is why they have been again directed to file a fresh affidavit matching the Aadhaar card and their name, because the nickname and the name appears in the Aadhaar card is different.
I'm listing it on How much time?
They have to say. They have to say when.
May I permit to place in first case, my lord, CRLMC 4945. Only one person's name mismatched.
अरे जियो हो.
Whatever, they have to verify.
और सेगुरा सब दे दो काम
Next week, my lord, anytime.
20th.
सेदिना अपन दे दो से हम दे दो
May I permit to file a affidavit, joint affidavit, even if joint affidavit is submitted before the IIC, perhaps.
Same thing you file it.
Everything
And
is-
want it only to verify
My lord.
complainant and accused.
सेटा के मैच न होले हमको डायरेक्ट
village आपको
Before honorable court or before the IIC?
before the IIC. Before the IIC. Same thing.
Yes.
73.
So joint affidavit.
City रा enter जरा स्कॉट.
This order, a criminal case was issued against the petitioner.
Enter जरा स्कॉट.
On the basis of the Lokayukta's order, a criminal case was initiated against the petitioner. Now subsequently, that Lokayukta's order has been stayed. Now pursuant to that, the vigilance court has proceeded with the trial, even though there was a stay of the Lokayukta's order. On last occasion, that is on 31/2024, the vigilance department has filed an objection to the that petition, your lordship. There are certain factors that are disputed. I'll give a short reply to that, your lordship.
Vigilance case. 73.
My lord, I am appearing for the OP number 5, my lord.
Let him file, Mr. Let him file. Mr. Vishwal takes time to file, respond to the objection filed by the opposite party, 1 and 2. Let him do so within 2 weeks. These the matters.
There's an observation that if the trial will proceed, I can make an application for adjournment, your lordship. That
observation was not made earlier.
It was there, your lordship. The first it was there. Second,
Same entry mode. Same entry.
My lordship. Much obliged.
74.
Relating to that release of that vessel. Now, so far as I was showing the earlier division bench order of this court, which says that these conditions are not to be imposed. The conditions regarding bank guarantee.
3 o'clock it will take. Is already another court. 2 minutes before 5 minutes stay.
Wait 5 minutes.
Only 5 minutes. I'll be saying.
अब तीनटा अच्छी सार दबा.
तीनटा सार दी तो.
अब तीनटा सार.
Yes. 2011-75.
325 conviction, 2 years.
2011. What
Yes.
the age of this?
Age is small age, not so. 35. Age is 35.
Jane Panda. We have to issue court notice to the advocate.
Yes.
Huh?
Yes. Nobody is appearing, so let notice
None
be
appears
issued.
for the petitioner. Issue court notice to the land council appearing for the petitioner.
Also, my lord, the direction may be given to state council to obtain instruction whether they are alive or not.
नहीं तो कम एज भरा.
एटा के दरकार नहीं. हां हम सेटा जान नहीं. एटा 35 years कोन एटा.
On behalf of Mr. Vasudev Pujari, I am appearing for the petitioner, my lord.
Yes, tell me.
My lord, kindly allow 2 weeks time as my learned senior is sick.
And this
But
is
you can argue 2011 matter.
I'm very new to this.
the 7 years conviction, 376. Conviction, 7 years punishment.
Against the conviction.
Conviction.
Yes, ma'am.
Age is 32. 32.
So, land council the petitioner speaks time. Then so land council for the petitioner speaks time. Seeks an adjournment on the ground that his head leader is not well. Leave the matter on.
Obliged, ma'am.
77.
Nobody is coming. What?
This is conviction 353 and other bailable offences to 323, 341. And maximum imposed fine 1000, default SI for 2 months.
First order is court notice. Nobody appears for the petitioner. Issue court notice to the Land Council for the petition. For the date change. Good a date change so that we can start hearing. March.
ये सब केस रे जो माने आसुना लॉर्डशिप लॉन्ग टाइम दे देगी तो नोटिस कर दियंतु so that the fresh case we can dispose of fresh cases.
Yes. Now exact 3. Yes. 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 Yes.
As per lordship, there is matter I filing the copy of the count.
Copy of what? Counter.
Just serving in court.
Here.
This is only damage. We are only against 2 conditions imposed by the bank. Now, the 2 conditions which are we are seeking waiver here is
Condition is with impugn order is phase.
impute order could be at page 177 annexure 17.
17.
17.
Yes.
And page
Conditions
177 is the impute order.
Conditions are
And the 2 conditions are at page 190.
190.
193. May I just show those conditions?
Yes.
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 The petition is directed to file bank guarantee of 10 crores.
Bank guarantee of 10 crores and 100 crores indemnity.
Indemnity bond to the tune of 100 crores.
Right.
Now, so far as bank guarantee, we are backed by 3 Supreme Court orders and division bench of this court and various other orders of high courts where this condition is not in.
Okay.
Because my lord, the contraband.
What is the objection, Mr. Paul? The bank
Today we have filed a affidavit. 3-4 things we have enlightened before my lord. First, the case is not maintainable on the ground of purity application is not maintained in the eye of law because against the order of a revision, they should come with a revision against the final order. So appeal lies. We are filing the appeal. Last that my lord is try to know whether the government has taken steps to file. Vetting is complete. Either today, tomorrow, day after tomorrow, we will file the appeal against the same order. So, in regard to the present order is concerned, there are 2 things is coming to this knowledge of the court. One way they are proceeding for release of the vehicle. Another way they are filing an application not to appear on summons. Now conduct is coming to such a level. Now what submission I made before last date, they come and interact the same. Now we are back down to file an affidavit that after getting investigation, because yesterday we have thoroughly discussed about the matter and give the details. In appeal petition, we are taking different grounds in this regard. That was only ground they have, bona fideness is that. It is admittedly a captain has intimated us. It is not mean that the person those have involved, they have exonerated from the criminal charges. Because it's a very premature stage and we have not started investigation. Only we have seized the vehicle on the information of their captain. Then which country they have uploaded it?
What happened to that admiral suit?
In that suit, I'm just a minute, my lord. In that suit, even though we are the seizure, we are the investigating agency, prosecution, they have not played as a party.
We are not the
Number 2, the state referred by the superintendent, neither of the council.
Why are you not moving application under order 1 rule?
Now we are, because we don't have a knowledge. After my learned friend is submitted to the court, the admin suit is pending all these things. So I advise my officers, they came to know that.
What is the order?
Let me be very fair to them, man. What has happened here? Let's take this on a neutral wicket. We discovered certain strange packets. We intimated the authorities. Thereafter, they came in, and those packets were in a place which is not visible to the naked eye. So after detecting that, we intimated. That is admitted by them. I'm grateful to my learned senior that he admits that. That's also admitted by the private plaintiff.
But at the same time, he says that merely because you have informed, doesn't exonerate you from the
That means
liability.
the master, the main person, he intimates. I'm not saying that it might be that some of the crew people may be involved. That's a matter of investigation. We bow down to that. Now,
You have in the lighter vein, you have the same defense like Lalu Yadav. He
No,
says that in the Potter scam, I have the informant, I become the accused.
No, it is
and
not,
he got
it's not,
convicted.
equating that, Mr. Yadav, Manoj, is very, I take offense to that, Manoj. It's not like that, not at all. That's otherwise, Manoj, I wouldn't have submitted to this. What we are proposing, Manoj, the ship has not committed any offense. It's a non-living. Across the board, the courts are releasing the ships with absolutely personal.
And there are
bonds.
two things which is now coming. Insofar as the conditions are concerned, it can be altered, it can't be altered. We have to see on the basis of the valuation.
Because we are filing
loss causing to you, that has also be taken into consideration. That's not a issue. There are two things apparently which is coming on record. One is this order is being challenged by them.
They are saying that we will challenge in future.
No, it is a process.
It
It is not a private company. We also tried vetting. After vetting, Lordship may noted it. I am submitting you the code.
That's right.
The vetting completed by today or tomorrow. We'll ready with this appeal and file.
What happened to that admiral suit insofar as the interim order is concerned? You show me that order.
Yes.
If you have, it is disposed of.
No, Admiralty suit is pending. There is an arrest order against the ship under the Admiralty jurisdiction. It is a private dispute between a terminal owner and the ship owner. Now, my lord knows that for the Admiralty court to get jurisdiction, first the arrest order is passed. Then it's a commercial dispute whether we will offer security or whether we can seek for reduction of that security is a matter of that suit. My lord may take it from me that there is no overlap between that case and this case.
No, if there is some kind of injunction, I can't possibly alter the
injunction.
Order. Let us see that.
What
is the tone and tenure of the injunction?
That injunction, here all that we are seeking for is modification of the two conditions imposed by the trial court on the touchstone of the judgment of the Honorable Supreme Court.
That's right. You are right. Absolutely right. I'm not on that. These are two things we have to
don't
overcome.
want to hide anything. We'll give those orders. But my lord may take it that there is that's absolutely an overlap. That is this 482 should not at all be concerned with that order. Because that court, in any case, we cannot leave with unless the court releases it.
Once again, I am clarifying, my lord.
No, just let me complete. So here, my lord, so far as the Admiralty order is concerned, it should not stand on the way of any of these orders. That is not at all connected with this case.
Give me that place that on record. That has to be seen. What is the impact of this? Admiralty order. Very good. You must place that on record. I will have to see.
We would quickly get. Now, my lord, so far as the Admiralty order is concerned, your lordship may take it. We will give it to your lordship. And there's nothing. There's an amount of 8 crores which the plaintiffs have claimed against us. The court has passed an interim order of arrest. Matter is posted to 7th of March in that Admiralty suit. That is the status of that case. So far as release is concerned, we will move applications for release.
Release of
the vessel.
But there is an arrest order already.
There's already an arrest order. But that is not linked with anything, with this. Now, if your lordship don't modify these conditions, there are two options available. We comply with the direction of the trial court and leave. Of course, subject to what the High Court says, because there's an arrest order. Unless, if we are not able
to... In the face of that arrest order, even if I modify, you can't take it back.
It is just like, Manoj, I'll tell you, one accused person has 3 bail applications pending.
Now, what will be the impact once I modify the order? You take the vessel. What will happen to the jurisdiction of the admiral?
If your lordship modify this order,
the jurisdiction also goes.
No, because there is already an arrest order. There is already an arrest order. So, my lord, suppose there are two orders of this court. My lord vacates one order in a separate writ petition. The other order still remains. I have to go before that assignment and get that vacated.
That's right. That.
So here, my lord,
but it's again a kind of academic situation today.
But then, my lord, may kindly see our predicament. Now, if we come before your lordship and seek for variation of the trial court, your lordship says that wait for that order. I go there, and there the court says that no, wait for the criminal court order. In this process, we are losing valuable time. The division bench says 2 weeks is the maximum period after which you should release the bench.
So, I think.
I'm trying to make legal points here. The only problem here is the quantum. It's a 100 crore ship. The only problem is that 22 kgs of cocaine have been seized at our instance. That is admitted across the board. So what is our mistake, my lord? We intimated the authorities here. That is our mistake. Now, if this is what is being meted out to us, my lord may see, it is probably the courts who should lean in our favor and facilitate the ship being moved. Now, we have clear, concrete instructions. If they want the crew members, we are willing to keep them in India. Wherever they want, let the ship be released.
If you are so keen for the release of the vessel, why don't the owner of the vessel is cooperating with the investigation? And why think
Exactly.
that you are not facilitating the investigating agency to proceed?
Each of the
You can't have the cake and eat it also.
No, my lord, if that 482 is not on board, that's coming up tomorrow. Regarding that, my lords, let me be very candid with your lordship. Your lordship has seen
tomorrow that matter is listed.
Tomorrow.
Yes, tomorrow, this is regard to the
No, my-
against someone they come forward.
Matter tomorrow.
No.
You tell me whether you have filed it or not.
Just one second.
Yes, yes.
My lord,
And Admiral,
no,
arrest
here we regarding the owner's appeal.
Hmm.
Let me, because my lord, here is a foreign national, a foreign company who is trying to seek justice before your lordship. Now, regarding the owner's appearance, that
justice
is
can't be one-sided. You,
No,
you have to respect the law of this country also.
My lord,
You have to cooperate with the investigation.
If there
You
are
can't say that I will
allegations-
not come, but give me.
We have not started investigation repeatedly and saying that because non-cooperation.
And contraband were found in the vessel. Investigation is going on. At your instance, maybe the contraband was found, but you have to respect to the law of this country and cooperate with the investigation. You can't say that I will not cooperate with the investigation. Give back my vessel, and there is an arrest order already there in Admiral.
May I submit?
And it will alter the jurisdiction of that Admiral.
Please, my lord, let me clarify that. It will not alter.
It has an impact.
No, absolutely not. Absolutely, my lords, that is it's a mistaken position of law which the court is having. Admiralty jurisdiction is an independent jurisdiction. The Admiralty judge has already exercised his powers. There is an arrest order. So this, whatever happens,
you know better than anyone else. The moment the vessel is taken away from this country,
my lords,
an application would be moved in Admiral Court saying that you cease to have jurisdiction.
my lords, now that
Then what will happen?
my lords, now that the arrest order is there with the shipping authorities, we cannot leave. We have to take the permission of the Admiralty judge. The designated judge, Honorable Justice Narsingh, is in session of that matter. So let me clarify one thing, my lords. So far as there are 2-3 issues which is troubling your lordship, I can apprehend. One is if your lordship allows this. Now in the pecking order, this is the easiest. The Supreme Court all across, they say that so far as vehicles and movables are concerned, you release them for narcotics at the earliest. So this is the easiest matter that I am moving. Second would be
easiest for you, not for the court.
Easiest for court, my lord. My lord would obviously, my lord.
Had it been a vehicle, I would have not looked into it.
My lord,
I would have on the indemnity bond. I would release it.
My lord,
it is a vessel.
That is the
it
law,
is
my lord.
related to jurisdiction of some court. It is related to the people overseas. Those who are not cooperating with the investigation. Initiated though at your instance,
let me address because I'm
you have to respect the law of this country.
Midway, my lord is trying to tell me something. Now, 3 issues arise: modification of these conditions. Second would be appearance of the MD. Third would be the Admiralty. At least, my lord may take it from me that Admiralty jurisdiction and here they are not connected at all. my lord's apprehension that if my lord modifies this condition, then my lords, if why we are seeking justice here is because this is something which is in accordance with the laws of our country.
I understand. To that extent, I can I can very well say modify the order and subject to the arrest order, it can be released. That I can
Yes.
do it. That's not
That is all that we seek, my lords. Now, so far as the
I can do it.
appearance of the MD, I am not being able to tell your lordship. When I
Subject to any other, the vessel will be released.
Yes, that
I modified the condition. That I can do.
Not not only the Supreme Court orders, but all across the High Courts, they have decided in that manner. That is how this matter has to be proceeded. So far as the appearance of the MD, let me be very candid with your lordship. When I moved the matter first, my lord has seen the ministry's guidelines. For a foreign national, they have to go and deliver. The law is very clear on that. They have to go to that country. My lord knows how the extradition of all these terrorists happens.
It's not a.
No, my lord may hear me on this. My lord may just hear me for a couple of minutes, 2 minutes only. The law is that you have to move to that country. Through the embassy, you get those summons. If the country agrees, then the person comes. It's a very long drawn procedure. Your lordship knows that, they also know that. But what fell from the court, that why don't you cooperate? This is a matter, you appear in VC. Thereafter, my instructing counsels, they have had long discussions with them, and we did tell that the court is of the view that you appear through VC, the matter can be resolved. Then they were extremely reluctant because they don't want to submit themselves. They have also studied the law, man. The ministry has come with specific guidelines how a foreign national.
Accused study the law more than the lawyer.
They are advised by international councils who are much more.
We are not less than anyone.
So
don't underestimate.
Neither
you underestimate
I know that,
not the court of this country.
I know that my lord has understood that law perfectly.
And why do you too also?
Yes. So let me comment, my lord, what I am commenting. With great difficulty, we made them agree to appear in this. The day I was supposed to come and concede to that, I had another matter, I couldn't come. On that day, my friends also, so it fell from the court, they had agreed to appear in VC. My lord may kindly recollect. Now, on that day, my learned senior appeared for the first time. He gave another proposal, saying that you come down here physically. Now, that is something where the matter is stuck. So far as the
and he made a statement that he will not arrest also.
Fair enough.
I'll record.
Fair enough. But the first occasion, the proposal of the court was you appear through VC. So that we are agreeable, your lordship may record that in writing, we are agreeable to appear in VC. What we are trying to suggest to them is let him as a first brush appear through VC. If they further want him to appear, then we are before your lordship. So far as the crew members, we have a concrete proposal. 21 of them are there. 21. All 21, we are willing to keep them at Bhubaneswar or any other place which they want. We will fly down 21 crew members from a foreign country. Let the ship be released. This is not bending backwards. This is the best that we can do. With this, if your lordships, we can't appeal to your lordship's mercy, I can't then.
No, see, then
I have to wash my hands off.
In everything. Mr. Body,
this is the best.
Mr. Body, what he says is, let us come to a conclusion.
Yes.
Because it has to go ahead.
Yes.
Investigation, release, and everything has to go ahead. What we can do is, insofar as these conditions are concerned, to what extent we can modify, let us examine.
Yes.
See, this release of the vessel will be subject to the arrest order passed in the admiral suit. Obviously,
that I know on. No problem.
That what he's correct there. Once he goes there, they'll say that go to the criminal court. Once he comes here, I'll send him to them. Then there, it's kind of pendulum situation for them. So we can very well modify if it is necessary, and if you can satisfy the modification is necessary, we can modify the condition with a rider that subject to the arrest order passed in the admiral suit, it can be released. There is no problem in that. Insofar as the appearance is concerned, tomorrow the matter which is coming up, appearance is concerned, I will record your statement. Let them cooperate.
My lord, I'm just clarifying two things. This is the application against the order of 457 CRPs.
Yes.
They made a 457. Yes. Sir, 51. Yes. Sorry. This is a application filed by them
impleading the state as a party, represent to the superintendent is not legally permissible because central customs department cannot be under the state. So it's required to be rectified, my lord, because our council who is appear there, he is not elected to the court.
You have not got an opportunity to contest this.
Yes, one state council is appear and they are acted on their own way. This DRA council is also appear there. They have not enlightened this. It depends to the Union of India. Nobody is listening this. Against the same order, because the basing on the insurance value, we are not assess the real value now. According to the insurance value, it is coming 118 crores.
118 crores.
Yes. So now we are coming with the appeal. We didn't agree with the interim order of the court below, and we are challenging them who will be educated by the my lords. Number 2. Number 3 is a very important case now. He is coming and filing entry short without implementing the party. As the party is not coming with a fair hand, now we are going to file application order 1, rule 2 or rule 10, and we are implementing ourselves as a party admitted suit. We are filing appeal in this case. Now the question of giving undertaking, they will not be arrested because the status have been changed. They are not coming with a clean hand to this court. So in this contest, tomorrow, what I am praying, my lord, tomorrow matter will be taken up, but this matter can be taken after 7th, after admitted suit, because once a court has given a direction for interim order, once a court has given direction for interim order, it is not only prejudice both the parties. One court will pass one order, another court will another modification order. Definitely a class of interest of the Union of India.
No,
so what I am praying, my lord.
What I am trying to do is only modification of the.
My lord, if my lord will modify this, our
release order already there.
My lord, what I am saying, against this said order, now the department, Union of India is filing an appeal. It will file by tomorrow. My lord friend is because he is assigned to discuss. He will file by tomorrow. Today is ready. Betting is coming. We will file it tomorrow. So after filing the same, court will decide this application or appeal, then come to a conclusion. Number 1. Number 2, as regard to his conduct, as regard to not to come to India, he is not appear to on someone, and they are very much interested to appear in virtual mode. It is not acceptable because this I was specifically stated that.
No.
But what happened, I am clarifying.
You are going to challenge the release order itself.
Yes.
Okay.
Yes.
And he is not challenging that. He is only saying that condition. If the release order goes,
it is his interest, my lord. We are saying that we are saying that the interim order passed by the court bill is not correct. Because the vessel value is some different. And reducing the price, what my learned friend is citing about the Supreme Court judgments or other judgments, always the court has seen the bona fide of the party, what fairness they have adopted, and what is the value of the vessel. That was not taken into consideration by the court below. Only they have given 100 crores bond, the 10 crores bank guarantee, which we dispute now because after this.
They are agreed by that first condition only, 10 crores.
Yes. So what
bond they can give. No?
So what I am praying, my lord, this because we are filing appeal.
Indemnity bond is commensurate with the insurance value.
Yes.
Because 117 crores, 100 crores they are giving.
Yes.
There is no problem in that. Only the 10 crore bank guarantee, that is the only hurting them.
Indemnity bond of 100 crores we will give.
You have to give.
Otherwise, what happened, my lord? The appeal filed by also will fluctuate.
Instead of 1%, 5% will give because we can't get a single person having 100 crores value.
One solvency is what the order.
One solvency is the order. 100 crores we will give, make good. But 5 instead of one solvency.
Yes, one. Oh, that's right.
What I am suggesting, my lord, let's keep it to after 7th, any day, 8th or 9th. Let them come, this party concerned, let them come, if here is established bona fide nature with officers concerns. Everything will be sorted out because after 5 months, the vessel was sell out to somebody else. He has purchased something. It is not that easy. What happened, this vessel is coming from different place. Then the owner is come forward before 5 months. The captain who informed us, he was also coming newly. The person, 5% says then either...
He has purchased the vessel recently.
Yes, recently. Thereafter it was found. And it is coming for the 3-4 countries. The strict law is very strict. Knowing well that this is there.
These things I need not go into. Only
yes.
I have to
see yes. That's why because the Union of India is filing the appeal. Let my law page correct the cast title.
Learned senior is repeatedly saying appeal. Now Pepsi Foods, I have got the judgment. There are 2 options. either a revision or a 226 or a 480. The choice is with the party.
Oh, sorry, yes, he's correct. My lord, he's correct.
So what
Revision.
appeal is he saying? Revision.
He is correct.
So if
Revision.
now, my lord, the cat is out. If they file a revision,
A final order where the appeal is not provided, revision.
so suppose he files a
simple as
revision. Now, my lord may see, I'll have to run from.
It
that
also
court.
converted to revision also.
So now, if they move a revision, then it will be before another court. Then how do we resolve this?
It is not a question of getting the matter by any court.
Don't take that objection very seriously. I'll relegate you to a revisional court now.
No,
because you have also challenged the same.
No, my lord.
Because I am entertaining it because you are challenging the conditions only.
My lord, in fact, 482 is maintainable.
So therefore, I am entertaining. Otherwise, it is
So
also
it is not a
it
case
is also
where-
a final order.
My lord.
Appeal doesn't appeal is not provided, so you should file a revision. But I am entertaining 482 because it is only the conditional change.
And in
So
any
therefore-
case, Supreme Court judgments are clear to that effect. I can file.
Then let us not go to
Yes.
that.
So now tomorrow if they file appeal, what appeal they will file, where I don't know.
Revision.
Revision, yes.
So if they file a revision, then my lord, this would be again has to go before the chief. He has to assign both matters to one court. Then we are not looking at solutions.
I am trying to find out a solution. So
Their revision is not on board, you know.
Investigation will
Tomorrow
start
will file an application on 397 401. And this case, this case may be come to anaglously. And my lord tomorrow will file and day after tomorrow any day lords may fix. Then our case and their case may be taken up together. As regard to the present 36 concern. As regard to maintenance concern, the state can be represented through the customs department. If
But
they want,
here,
they can.
here see in the cost title they have said
Yes.
superintendent customs.
Yes, it is a union of India, cannot be depended by the state, my lord.
No, before that court below that is the
Ah,
cost
that's
item.
because neither the anybody enlightened this court below, nor in the High Court. When we examine this, how
State
state
represented through the superintendent of customs, prevention
prevention.
commissioner.
Yes, how it
What
can-
else they can do?
No, they should mention the Union of India. Otherwise, every officer can approve the Union of
But
India.
when I see the nature of objections, we have mentioned on day one, we have given advance.
Because affair was lost by the department only,
So
customs
that-
department.
So these are small technicalities.
Yes.
Forget about it. Let's
So
find
that's
out
why
the
what I'm suggesting, let them correct it. Not an issue because otherwise this order will be.
Since you are appearing, what is the?
Yeah, I'm appearing, but I cannot appear on the state. State will defend council will appear and
But
their locus will be correct.
here they have said Union of India, second state of Orissa represented through the superintendent of customs.
Served copies to both.
And
We don't
Union
want
of
to
India.
run
State may either state may be written or state may be deleted, whatever may this is. But we are not appearing for then OP number 1. For Union of India, we are appearing. Depend by anything.
You are representing the superintendent of customs. Preventing.
We are representing, but the state of Orissa represent through the superintendent. How can I appear?
You correct it.
Yes, that's why I'm saying it's correct.
Correct. Whatever, let him say what cost title he wants, we'll correct.
Let us
This
not
is
go
a
into
technical objection, my lords. On the third date, the matter is being taken up. I've given that admiralty order. I'm sorry I couldn't give it earlier. You can give it.
Have you got this copy?
Yes.
Yes.
We already
My
saw.
lord, now with let me, it's a humanitarian problem. People are losing their minds. There was one attempt to suicide by one of the crew members. The ship is locked. We have bent backwards.
Why didn't you take them out from there?
My lord, the place they have said, yesterday I've seen the photograph. This custom department took very much pain to recover the person. This you may see the tower, just like. From there, they're keeping boxes. So first day they have recovered 8 boxes. Then found, then 14 boxes.
But
Then the generally, without the knowledge of the captain and the.
No, I am asking something else. The people, those who are confined there,
Yes.
inside the vessel, why don't you take them out from there?
That part I will take instruction, my lord. I don't have that instruction.
Take them, keep outside in the land.
It's 90 days and
90 days, see the psychology of those people.
As far my knowledge is
Across the
concerned,
bar,
when
he-
the
he
ships
did
are
admit-
coming, they are
he can
spending their
actually
life in the ship only. It is not
He
that.
did admit that the first intimation was from the master of the vessel. So at least that bona fide is proven. Now, my lords, because of that one information, we are in this kind of a soup, my lords. Let my learned senior examine the humanitarian aspect of it. The commercial aspect I have already told, around 20 lakhs every day is the business that the ship would count. Supreme Court judgments repeatedly say that holding the vessel back even for more than 2 weeks will, the vehicles will make its value depreciate very quickly. And the division line says that not later than 2 weeks you should release the vehicle. This is 90 days. So in a way, my lords, there is no respect for the orders of the court. And across the board, my lords, 3 Supreme Court judgments which have been written. Nowhere these conditions are imposed of bank guarantee, give this. It's a personal bond across the board in NDPS matters.
Okay, we will hear tomorrow. Tomorrow, keep it tomorrow. I'll just go through this matter. Keep it.
My lord, may I play one thing?
Yes.
Tomorrow, let's may keep it this matter that about the summons issue.
That is
But
already.
tomorrow we are filing the appeal. Day after tomorrow, next week, any day, let's may keep this matter along with our revision application. Both can
So
you take?
revision, I don't know. It will not come to mind.
Revision is
Okay.
not asked. So if they are proposing to file something to be fair, let them. I can't block.
No.
They should
What I'm
file
saying,
for-
I'm saying it. You to what
In
is
view of Pepsi Foods 482, 226 revision, all 3 are maintaining.
No.
If they want this
Neither
court,
you can advise nor I.
no, my lord,
There
but
is
then
a-
if first he began with an appeal, I thought, my lord, where the appeal would go. Then
my lord, I'm
That we
extremely
can't-
sorry.
Can't tell.
I'm not well today. All of a sudden, I come and submit that. It is a case where the department is taking very positive steps as regard to the investigation part is concerned. The concerned officer are very serious about the issue and they are investigating very thoroughly. Because they are not getting any sources from their side, we are also feeling handicapped. Now question is coming, they are filing application, they are getting the interim order. And even though whatever order is
You
passed
have
by
not
the
got any interim order.
no, that is the interim order for release of the vessel.
With conditions.
Yeah,
of
what
the agreement.
with a condition.
If
So
they,
if
they were
in extreme place, my lord will not
comply with
allow.
that condition, they would not have come to the court.
Yes. So against that also we are coming. The coming a private party to the court and coming with a Union of India to the court is completely different. We have some paraphanias. We have to maintain this. Then we will come to the court. Everything is settled by tomorrow or day after we will file it. So let's see, keep it next week any day. And by this process,
Yeah, let us see tomorrow.
Yes,
With the other matter is there, let us see.
we are before this court. Let there be an interim release. Let them, because if there's an interim release, we have a prayer for interim release.
Unless there is a release, where is the question of interim release?
Interim release without those conditions, let the matter.
Then that means in the interim stage only I'll allow your petition.
My lord,
There is a release order.
My lord.
Where is the question of
only
interim
the
release?
waiver of 2 conditions subject to the admiralty. My lord may release
The
it.
condition has to be seen whether
Yes.
see it is
And
the value is
we
so
are
much.
agreeable to keep the crew here. Let them, because they are involved with the men who have committed this.
See, the task of this court is to see the 2 conditions are fair or reasonable or not. That has to be looked into in the light of the judgment and all. So there is no question of interim order because you have got a release order. And the release, even if where is the question of interim release? If there is an arrest order by the Admiral Court, even if I pass interim, what will you do?
I bow down. My lord.
This is neither
We are
here nor
moving
there.
an application for release on before the Admiralty Court also. That those steps we are in the process of.
Have you gone in appeal against the order of Admiral?
We don't intend to
arrest
go.
order?
We don't intend to go in appeal.
You move an application there.
We will move before the very same judge an application.
That's your.
We are willing to cooperate with because that's unless we had faith in this system, we wouldn't have intimated the authorities. My lord knows with my lord's wisdom what happens in the private courts. I needn't say when contrabands are found, matters are hushed up. We cooperated with this. My learned senior is not listening to me, my lords, but this is precisely the point. He does.
Long and short of the matter that you have invited the problem for you.
We have, but now we want to resolve it in the earliest possible. Time is the essence here. That's why, my lords, I'm begging my lords to put a shorter date so that this ship at least.
I'm putting it tomorrow. What short?
my lord, may I pray, my lord, can it be 2 p.m. or after?
Yes, after.
Oblige, my lord.
Yes, first hour.
Tomorrow at 2 p.m. there would be a matter. So can I?
No, 3.
No, can I request at 10:30?
No, not 10.
10:30, we have a matter is fixed in Chief Justice Court for.
No, 3:30 p.m.
3:30.
Yes, oblige, my lord, oblige.
Let it be indicated in the list as 3.
Yes, it's 3:30.
We are all great.
Oblige.
କିଛି ଅଛି ଅସ୍ତ୍ରପତ୍ର ଆଗରେ ନା ଇଏ କରିବାକୁ ଇଚ୍ଛା ନାହିଁ।